Yes! Hello, my beautiful friends. What an amazing day it is. I am so glad to be here and with you. We've got a bunch of stuff happening. I know it's President's Day. I know most of our government is just taking the day off, but not us here. We've got some serious business to attend to. We're going to the Supreme Court, baby. The president and his team have submitted this filing, and we're going to go through it, starting with Hampton Dellinger today and their application to undo what the lower court judges have done. And remember, this is the case that we're talking about. We're digging out our mind maps again because there's so much going on. We got to keep track of it. But remember, this is the case involving Amy Berman Jackson, the Obama-appointed judge, and it is Hunter Biden's classmate that Biden appointed back in 2024. The judges said that Trump firing this guy called Hampton Dellinger was illegal, and he has to come back onto the special counsel's office. And so we will go through what Trump is demanding of the Supreme Court, saying they want an immediate administrative stay, and we'll go through the juicy bits. We love knocking on the door of the Supreme Court, so that's coming up. Then we'll turn our attention to what the latest is with Doge, because they had a hearing today in the District of Columbia, the district court there, and we're very familiar with this judge. We spent a lot of time with her. Judge Tanya Sue Chutkan is back. And this is curious because today there was a hearing and our friend Margot Cleveland was live tweeting it because she's amazing. And we'll see what happened inside the courtroom, but it doesn't look like she is going to grant the state's request to stop Elon. And it's a bunch of these states: New Mexico, Arizona, Michigan, all the blue team, all jumping in on this. And so we'll see what happened inside the courtroom before we jump into the latest on Doge. I got a bunch of clips on Doge that we'll get into, and then we'll round out the day with Fani Land. And of course, Fani Land is Fani Willis in Fulton County, Georgia. And she's also going to the Supreme Court, already has gone to the Supreme Court since she's been disqualified. But what we'll see is that the defense team, no longer involving Trump because he's, the president. Sorry, Fani, your little scam didn't work. Locals just kicked over. Hello, locals. The petition for a writ of certiorari, the response coming from Rudy, Michael Roman, Cheely, David Schaefer, Latham, the rest of them, they're all taking this case up. And remember who we heard about back during the Fani Land saga, Ashley Merchant. And so this is her team and a bunch of other lawyers all submitting this. And we love our trips down to Fannyville in Georgia. So bunch of great stuff coming up. Really glad that you're here. Hopefully your weekend was outstanding and amazing. And your Monday has been unfolding oh so beautifully. And you're feeling refreshed and restored and ready to go. We'd love it if you became a member. We had a great members only stream this morning, and it's a ton of fun. So you can join as a member on YouTube or come over to Locals, go into a web browser, type watchingthewatchers.locals.com and become a member. And we'll see you on the members only morning streams and our Saturday streams, which are also a lot of fun. So we'll see you over there. But now, without any further ado, let's get into business on the day. President Trump goes to the Supreme Court. You can see this is their application knocking on the door. And it involves this case involving Hampton Dellinger. And we're familiar with him because he's been filing lawsuits and appealing this and trying to keep his job. Remember, this was the guy that President Trump fired immediately on day one. And he was in the office of the special counsel. Biden appointed him. And he was somebody who was Hunter's classmate. Very interesting. And when all of this broke immediately, okay, Trump fired him, he sued immediately. This case went over to Amy Berman Jackson at the lower circuit, at the lower district level in Washington, D.C., in the D.C. circuit. And she was appointed by Obama, and some weird stuff happened because she basically very rapidly gave him and ordered the government to let him back in without even basically hearing from the DOJ, Trump's DOJ. Said, you're back in charge. Get in there and just start deleting whatever you've got or whatever. She didn't say that. That's our implied belief. So he is suing. And then what happened is we took this up to the Court of Appeals and went up there and back down 2 times. And they said, sorry, Trump, you've got to keep this guy in office. So then what happened is Trump is now taking this to the Supreme Court. And this comes after, remember, Pamela Bondi, we covered this before, said she's no longer going to defend the Humphreys executor case, which is basically reverting us back to this concept of a unitary executive, where the executive executes the law and Congress can't create these little wishy-washy offices like the Office of Special Counsel or like Elizabeth Warren's operation, the CFPB. Okay, all of these entities they just create that are just kind of made up. They're kind of in between Congress and the executive branch, and the president doesn't have any control and Congress doesn't have any control. So then everybody is just grifting all over the place. Well, enough of that. Trump is saying, we are the executive branch. There is one president, one branch of government that does this. That's us. And so we can fire this guy if we want to. And we did. And so Supreme Court, here is now what we're asking from Sarah M. Harris, acting Solicitor General, who is going to be representing the Trump DOJ, taking this up to SCOTUS, knocking on their door. Says, all right, listen, ladies and justices, application to vacate the order is now what we're submitting, and we're also asking for an immediate administrative stay. So Amy Berman Jackson has said this guy can go and continue his job, and we got a lot of questions about this, right? She didn't even consider Trump's national security perspective. Was this guy dangerous? Did Trump know something that might jeopardize something somewhere? Just didn't care. No, you can't fire him. It's illegal. Elon Musk, dictator. Okay, and said he's right back in. And so now Trump is saying totally ridiculous. Says, look, Supreme Court, here's the deal. Pursuant to the rules of this court, we respectfully file this application demanding a stay. Here's why, Supreme Court. This case involves an unprecedented assault on the separation of powers that warrants immediate relief. Now, as this court observed just last term, the Supreme Court, they said this: Congress cannot act on and courts cannot examine the president's actions on subjects within his conclusive and preclusive constitutional authority. Oh, yeah, we remember that from Trump versus United States, including the president's unrestricted power of removal and with respect to the executive officers whom the president has appointed. Okay. And this is how it has to be in our Constitution. We have three branches. Clearly, there's no middle ground between the two. So if you start allowing or disallowing the president from making decisions that are within his exclusive purview, you're de facto creating extra constitutional operations. Trump's people say. Now, as to the principal officers, of which this special counsel would be, Hampton, the most important of his subordinates, the president's management of the executive branch is one of the most important duties, including the power to remove things and people. Now, enjoining the president and preventing him from doing his job inflicts the gravest of injuries on the executive branch. Now, in the last 5 years, Supreme Court, this court has twice held that restrictions on the president's authority to remove principal officers who are acting as the sole heads of executive agencies violates Article 2, which is the executive branch portion of the Constitution. We also talked about these. SELA law versus CFBP, right? Congress said the head of the CFBP, which was Liz Warren's little janky, whatever that was, Financial Protection Bureau that was supposed to be recouping costs for Americans, but turned into a little Democrat cudgel to go after their enemies. So CFPB, Congress said you can only fire the head of that agency if they're like really bad and like they're really offensive. So you can't do it. So it's our agency. Wrong. Supreme Court said, no, that's not how this works. The president fires him, said, okay, gone. Same thing here in Collins versus Yellen. And we read prior cases where this has also gone on with Social Security and other agencies as well. Now, whatever the agency, for the president to discharge his duty to supervise those, the president can remove the head of an agency with a single top officer at will. Okay, it's his power. Now, on that basis, Biden fired the head of the Social Security Administration without cause. Remember that one, Amy Berman Jackson. Thus, when Trump on February 7th removed Hampton Dellinger as the single head of the Office of the Special Counsel, right, one guy, he engaged in an uncontroversial exercise of his power, not even complicated. Biden did it, we just did it. Since the Carter administration, the executive branch has repeatedly expressed the view that tenure protections for the head of the OSC, Office of Special Counsel, violates the Constitution. That is because the agency presents a particularly clear-cut case. They tell us they have prosecutorial decision-making power. Decisions to prosecute somebody is an executive branch power. That's what the special counsel does. That's why they're under the executive branch. Now, the Office of Special Counsel operates as literally an investigative and prosecutorial agency. They go after whistleblowers, issue subpoenas, they do all sorts of stuff. And so the president's removal, accordingly, is implicated in two preclusive presidential powers that are the president's. You people in Congress are precluded from having any say in this at all, which is the power to remove and the power to control and use prosecutorial decision-making. Both the presidents, Congress is trying to usurp that. Now, for most, I think my entire life, right, this has been this little patty cake game between the branches of government that has been sickening, actually, right? It's one big elected oligarchy. And we want our branches of government to butt elbows a little bit and say, get the hell out of my business. No, you get the hell out of my business, right? So that we have very clear delineations between the two, lest we have what we've all been living through and are currently exposing, which is this game of patty cake between the two, where they just rub each other's back all day long, go to the same conferences and spend our money for their own grift. Now the executive branch is saying, these are my powers. Get out. You, like other executive branches, may have played patty cake with the Congress, but we're not doing that this time. So that's perfectly within our purview. We know it's causing a hysterical meltdown because your money is going away, but that doesn't make it unconstitutional. The country is not falling apart, so just relax. Yet within hours of the respondent filing suit, and before the government even had the opportunity to respond, this judge, Amy Berman Jackson, issued an 8:35 p.m. order on February 10th and just made it up out of her booty, called it an administrative stay. I don't know, what should I do? Perfect. Let's just call it a stay. You know what that stay meant? This guy goes back into the government. That order restored the respondent to the office, okay? The president removed him. The president is elected by the people. Removed him for whatever reason, made his decision to do that. She shoved him back in. Didn't even hear from him. Enjoined any efforts to impede his access to the resources or the materials of that office. And we're like, oh, yeah, he needed to clean out his recycle bin, didn't he, on that desktop, didn't he? And barred the president from installing any other person as special counsel. So then, on February 12th, the district court, again, Amy Berman Jackson, issued another 27-page opinion, which then she shifted her, quote, administrative stay. She turned it into a TRO. And then she said, again, Trump, you're banned, right? So this has more force than just a temporary stay. So the court then set the TRO to last for 14 days and specified that a hearing on an appealable order would not be held until February 26th. So you see how sneaky this is. So a temporary restraining order, okay, it's supposed to be, I know this is going to be complicated, but it's supposed to be temporary. That's why it's in the name. Temporary, Judge. What's so complicated? It's not supposed to last for like a month, okay, until February 26th. You issued a temporary restraining order, which is just extending the stay. Okay, so she's like, well, it's temporary. Okay, well, I'll have a hearing on it when? On the 26th. So this guy is in the office the entire time, doing whatever he wants to do. Trump has no power to remove him. Now, they say until now, as far as we are aware, no court in American history has wielded an injunction like this judge did. It's not an administrative stay. It's a forced act. He was fired. She's forcing him back in. Not staying the firing. The firing's done. And she doesn't have jurisdiction over the firing. To force the president to retain an agency head whom the president believes should not be entrusted with the executive power, and to prevent the president from relying on his replacement. Yet the district court, Amy Berman Jackson, remarkably found no irreparable harm. Well, he already worked there, and so we should just let him work there anyways. If he's judicially barred for at least 16 days and perhaps for a month. See, and when they say, see these other rules, allowing courts to extend TROs so they last up to 28 days. So it's not so temporary, is it? And when the United States sought a stay or alternatively mandamus, they said, wait a minute. We need to appeal this. And the reason she's keeping it as a TRO or a stay is because you can't appeal those generally. And like that's by design. So then they appealed it. And because she called it those things, she labeled it The Court of Appeals is like, well, it's a TRO. We can't wait a TRO until blah, blah, blah. Sends it all back down. So then the DC Circuit, the Court of Appeals, issued a 27-page denying relief late on Saturday night over Judge Katz's dissent, which they'll get into. So they say, look, Supreme Court, the United States now seeks this court's intervention because these judicial rulings irreparably harm the presidency. They are curtailing the president's ability to manage the executive branch in the early days of his administration. Now, as Judge Katzis observed in his Court of Appeals dissent, he says the TRO is not a TRO at all. It's an injunction against the president, and it literally requires him, like a TRO is like, okay, everybody don't change anything, just kind of keep things status quo so that nobody gets harmed. It's requiring him to reinstate an agency head who he removed, got rid of him, fired him, and she's shoving him back in. It's virtually unheard of, he said. It's usurped a core Article 2 power of the president, telling us courts may not enjoin the president regarding the performance of his official acts, regarding removal or otherwise. Otherwise, guess what? The courts become the president. Even when courts do not enjoin the president himself, this court has long held that a court will not by injunction restrain an executive officer from making a wrongful removal of a subordinate appointee, nor restrain the appointment of another, citing a U.S. Supreme Court case from 1898 that Judge Amy Berman Jackson apparently missed as she was squeezing this dude back into his office. So thus, challenges for removal have historically been litigated through suits for back pay. Okay, if Hampton Dillinger's so mad about this, he can go get his back pay. They were paying him anyways, I think. He can go complain about that, but he doesn't get his job back. He doesn't get access to his email back. There's a reason Trump got rid of him. So this court should not allow lower courts, they're going to the Supreme Court making this argument, and this is probably going to be the first of many, to seize executive power by dictating to the president how long he must continue employing an agency head against his will. Saying from Katzis, dissenting from the Court of Appeals in the DC Circuit, says, where a lower court allegedly impinges on the president's core Article 2 powers, immediate appellate review should be generally available. So we don't care if this is a TRO or an administrative stay or whatever Amy Berman Jackson wants to call it tomorrow morning, whatever. It is forcing the president to do something. That is an insane thing for a separate branch of government to do. When it's the president's core power, it's articulated in the Constitution. He can do these things. The courts don't have that power. If the court does have that power, they're the president. It violates everything. And she's doing it for a reason, in my opinion, so that this guy can get in there. It's an old Democrat from the Biden syndicate, and who knows what he's in there doing. And Trump probably knows, which is why they fired him, but the judge didn't even have the courtesy to check or care. Yet the DC Circuit Court majority described waiting 2 weeks for the Article 2 power to be exercised by the rightful president is not so prejudicial because he can do a lot of damage in 2 weeks. Now, if that reasoning is allowed to stand, it's hard to conceive of any TRO Supreme Court that would trigger appellate review. Such a ruling risks further emboldening district courts to issue TROs, stopping the president from taking decisions that he is allowed to do under the executive powers. Now, that is no mere hypothetical, SCOTUS. The district court's order exemplifies a broader, weeks-long trend in which plaintiffs are challenging Trump's initiative, and they have persuaded these lower-level courts to issue these TROs that intrude upon a host of Trump's Article 2 powers. For example, a district court in New York issued an ex parte TRO, which means Trump wasn't even involved in this. Somebody ran to the teacher and said, oh, man, Trump's doing this to me. And the teacher just believed him, right? Or mom just believed, didn't ask the other kid. And turns out the other kid was right. That kid's a liar. The first one who came up there and blamed the other kid. So anyways, they went in there, ex parte, Trump wasn't even notified, saying that Trump and the entire Treasury Department be limited to, quote, civil servants and be denied to political appointees. That was insane, right? That was Judge Vargas, another Democrat appointee, I think a Biden appointee, in the reckless Southern District of New York, said that you can't even allow a political appointee, like Scott Bessent. Do you know what his position is? Obviously, the Secretary of Treasury judge says he can't even do anything in the Treasury. What? They also point this out. A district court in DC issued a worldwide TRO that prohibited the government from suspending, pausing, or otherwise preventing the obligation of any foreign assistance that was in existence on January 19th, 2025. And if I'm remembering right, I think that's Judge Carl Nichols. I think it's a Trump appointee, right? Who said, well, this could be harmful because someone might die of AIDS somewhere. Okay, well, that someone else can figure that out, right? There's other prerogatives for that. Trump's order is the order. Judge, you don't get to say, well, that order is unwise or that might have some harm or whatever. If Trump has the power to do that, you don't get to second guess him, lest you become the president, and you're not the president. Many other district courts have also issued universal TROs that sweep far beyond the parties to those cases and effectively enjoin the president's orders before agencies have even decided how to implement them. Okay, we'll hear Judge Chutkan in the next segment talk about a prophylactic TRO, which is all they want. They say, look, the United States, enough, has respectfully requested that this court vacate Amy Berman Jackson's orders. The courts are trying to seize Article 2 powers from President Trump, and they're saying we can't appeal any of this in the meantime. This is ridiculous. This court should not allow the judiciary to govern and run this country by TROs and supplant the accountability that the United States Constitution ordains. Now, here's the facts. Knocking on the door of the Supreme Court asking for recourse, Trump's DOJ writes, Solicitor General says, Congress established the Office of the Special Counsel in the Civil Service Reform Act. The office began as, quote, the investigative and prosecutorial arm of the MSBP, the Merit Systems Protection Board. Congress made the agency and the office a freestanding agency in 1989, whatever the hell that means. Okay, 1989, a freestanding, there's what, where is in the Constitution that there's like a branch for freestanding agencies? The Office of Special Counsel remains, quote, an investigative and prosecutorial agency. It's on their own website. Okay, they prosecute people. The office executes certain provisions of 4 federal statutes. These are where they get their powers, and they promulgate regulations, and they may even bring enforcement actions, and they can require an agency head to conduct an investigation and write a report. Okay, look at how powerful this office is, they're saying. In fact, in fiscal year 2023, the office had 129 full-time employees equivalent, $32 million in funding, 4,600 cases, and more. And it's headed by a special counsel under U.S. Code. And the special counsel, as we'll note, is appointed by the president and has advice and consent of the Senate for a term of 5 years. That's under the U.S. Code, right? Trump came in and fired the dude immediately. Now, the special counsel has the statutory authority to appoint subordinate agency officials and more. So then, at some point, the Civil Service Reform Act, it says, look, you can only get rid of a special counsel. And this is the little crux of the strings that Congress tries to attach to these things. Says a special counsel, in this case Hampton Dellinger, may only be removed by the president only for inefficiency, neglect of duty, or malfeasance. And like you got to notify Congress and then make up a reason like he's been inefficient. Oh yeah, hell. Well, because he's, someone defending the Biden crime family and covering up for their malice. Well, that's not inefficient. He's just doing his job. That's prosecutorial discretion. Congress gets mad. They say no. They start an investigation. Then there's a calls for impeachment. Like you see what's happening. Congress just wants to have their people in there to stop the executive branch from making a change. However, since 1978, the executive branch has repeatedly raised constitutional objections on that restrictions and on the fact that the president can't remove this person. Carter brought it up, said this is crazy. You can't restrict the president's power to remove him. Reagan pocket vetoed a bill that would have given the special counsel more powers and more. In fact, in March 2024, though, Biden, with the advice and the consent of the Senate, put Hampton Dellinger, Hunter's ex-schoolmate, into this position. Then on Friday, he got fired. Friday, February 7, 2025, Trump came in, immediately removed him from office. On February 10th, he sued, got a temporary restraining order. Before the government could even respond to the motion, the court held a near immediate hearing. Hours later, the court entered what it called a brief administrative stay. She just made that up. That would last until midnight on February 13th. Now, that order restored that guy, shoved him right back into the office. The next day, the president designated the Secretary of Veteran Affairs, Doug Collins, to be the acting special counsel. But the court said, you can't have him in there because I put my guy back. Now, the government appealed the stay to the D.C. Circuit. They sought a writ mandamus, and they dismissed it. They said, sorry, we can't hear this. We don't have jurisdiction because it's only a stay. You know, we can't hear stays because that's why she called it that. In a concurring opinion, though, Judge Katsas said this is ridiculous. Indicated that the district court's administrative stay was not immediately appealable, but emphasized he expressed no view on the appealability or merits of any later order granting interim relief. So then, on February 12th, the district court issued what it said was a temporary restraining order. Said, until we move forward, right, the next step in this process would be a preliminary injunction. And said Hampton is still in the office until that time. Now, in issuing that order, she found, Amy Berman Jackson, that Hampton was going to win this. And we read this and we said, totally not going to win. But she said, he's going to win. And so that's why we're going to keep having him have access. The court acknowledged this court's decisions, recognizing, they said, yeah, the president does have broad authority to remove people, but it does not extend to the office of the special counsel. So Amy Berman Jackson, the lower level judge, she identified an exception to this. She said, well, special counsels are like special, so the president can't really govern over them because of some reason. And we'll see why that's so erroneous. But that was her explanation. Now, the court stated that the office of special counsel has no authority over private actors, does not have broad rulemaking authority, or wield substantial enforcement authority. Obviously, that's ridiculous. And doesn't affect a broad swath of the American public or the economy, which is also ridiculous because you have Jack Smith, who was a special counsel, which almost took out the current president. Turning to the equities, they say, the district court, Amy Berman, accepted the contention that Hampton is going to face irreparable harm because he has an entitlement to serve as the agency head. And it said that the hardships favored him because Trump didn't explain, right? No circumstances that required the president's unexplained action that would justify the dismissal. Trump doesn't have to run it by the courts. He's lawfully allowed to do it. He did it. He doesn't have to get Amy's permission. The same day, the government again appealed to the D.C. Circuit. The next day, the district court denied the government's request for an appeal, consolidated a bunch of stuff. Then, in a lengthy opinion that was issued late Saturday, just this weekend, the Court of Appeals once more dismissed this, said, we don't have jurisdiction over this. The court said, preliminary injunctions are appealable, but because Amy is calling it a TRO, those are not appealable. Okay, so we can't hear it. It's a dumb technicality. The court acknowledged that a TRO may be treated as an injunction, but doesn't qualify here. The court said the district court is going to hold another hearing on the 26th. Meanwhile, Hampton Dellinger can just sit in his office, shredding whatever. And one judge dissented. Here's his explanation. Judge Katsas, and this is knocking on the door of the Supreme Court saying, you got to fix all this. They say the dissent was right, Supreme Court. He first explained that although TROs are generally not appealable, as everybody agrees, this TRO, which orders the president to recognize the authority of an agency whom he has formally removed, qualifies for immediate review. Like, this has to be heard now. When it comes to judicial review, courts have long recognized the special status of the president. And for instance, he cited opinions that permitted immediate review of other orders, like in the Nixon case, or in the Cheney case, or other interlocutory orders rejecting Article 2 defenses in the Trump case, with Amy Coney Barrett concurring. Judge Katsas says this happens all the time, all right? These TROs are immediately reviewable. Why? Because they're usurping a core power of the president. You have to hear this now. Now, this is Trump's DOJ's argument. They say, look, you can hear this case. You may vacate under the All Writs Act and Rule 23 of this court. You can do all of this stuff. You have plenty of power. This case says you do. This case says you do. Here's why you can grant us a victory. These factors overwhelmingly support a vacatur of the TRO. Remember, so it's like of the forced employment of Hampton. Get rid of it. Trump is allowed to fire him. Here's their argument. They say, we are going to win on the underlying issue here. The question, can the executive fire the head of the special counsel's office at will? They say the likelihood is very high. First, the court's precedents are pellucid that Article 2 empowers the president to remove at will the single head of an agency like the special counsel. Pellucid, that's your word of the day. Second, this court's precedents are clear that district courts lack equitable power to reinstate principal officers, okay? So the president has the authority to fire people, generally speaking. That's clear. We also know that the courts can't appoint people, especially principal officers. They've crossed both of those lines and precedent, and they're threatening the separation of powers, and they're doing it obviously willfully for probably some reason. Don't know exactly what it is, but I hope that Hampton's keystrokes, every single mouse movement, every single email, every single packet of information that is pinged across every server all across the fruited plain and the world are found and tracked. And we are going to reconstitute that hard drive. So Article 2 empowers the president to remove special counsel at will. Trump's allowed to do this. They say, look, time and time again, this court, Supreme Court, has held the president has unrestricted authority to remove principal officers like this guy. Article 2 says this very clearly. The president has the executive power, and the president is directed to take care, capital C, which they always like to underline. It's like, well, they just are like order takers from the Congress, which they're not, that the laws be faithfully executed. The executive power includes the ability to remove executive officials. That's the seal of law case we've talked a lot about here. Now, otherwise, the president could not be held fully accountable. The buck would stop somewhere else. Well, that guy's responsible. I couldn't remove him. He did all of that. And so he's responsible for it since Congress said I couldn't remove him. No, it stops with the president. The president's power to remove those who exercise his executive power follows from Article 2, was already well settled many times. And thus the president's power to remove may not be regulated by Congress or reviewed by the courts. Trump versus United States, U.S. Supreme Court case from 2024. Now, applying that general rule, this court, which I believe that is the Trump immunity case, which they were talking about this, right? The executive branch, the president, cannot be criminalized or dictated to when the president is doing things that the president is authorized and constitutionally mandated to do. You can't charge him with a crime, and you can't take that over and say, well, it's our job now. It's delineated to him. Now, applying that general rule, this court has repeatedly held in recent years, the president must also be able to remove at will sole agency heads like Hampton. Now, as a general matter, they say, this Constitution scrupulously avoids concentrating power in the hands of any single individual except for the president. Why? Because that is the most democratic and politically accountable official in the U.S. government. Single agency heads must also thus, therefore, be accountable to the president with at-will removal. There are only 4 single agency heads upon whom Congress has sought to confer tenure protection. We add the CFPB, Liz Warren's little thing, the FHFA, Federal Housing Finance Agency, and Social Security, and the special counsel here. The former 3 are undoubtedly subject to removal at will under Article 2. And this court's precedent foreclose any special exception for the special counsel. So just like you could do it for CFBP, court found that and seal of law, FHFA, and Biden nuked the Social Security person, the precedent shows, right? How can you distinguish the special counsel from that? Because it's like a special office or something? Start with CFBP. In seal of law, the court said Congress violated Article 2. Like Congress passed a statute, but they can't override the Constitution, not without an amendment. They said, well, this guy can only be fired for inefficiency or whatever. Hey, that's ridiculous. And the court said, you can nuke that guy. They did. The director was neither elected nor meaningfully controlled. The director could unilaterally dictate and enforce policy. So that's why he could be fired. This court then extended the at-will removal rule to FHFA. Look at the Collins case. Same thing here. FHFA was also led by a single director. They said the president's removal power is vital. And in short, Article 2 empowers the president to remove the head of an agency. Even Kagan was concurring in part. Then came the single head of the Social Security Administration. We're now two down. Social Security Administration also got nuked by Biden, removed him. In supporting that decision, the OLC said, well, the best reading of Collins and Sela, which nuked those other two agencies, should be applied here. The only courts of appeals to have considered these questions have both held that statutory restrictions, right? If you try to hamstring the executive, you violate the Constitution. So if you're going to craft a special exception for the special counsel, it's going to contravene your own precedent. How are you going to logically shove in a special counsel's office if those other two have to go? The Office of Special Counsel is literally, as per their own website, an investigative and prosecutorial agency. It executes 4 federal laws, and they list them. A bunch of things, issue subpoenas and depots and more. They also enforce multiple statutes. They can bring court cases. There are executive functions there. They enforce the law. Many have described them as their prosecutorial arm. Okay, lots of stuff. Look at all the stuff they do. Wow, it's a lot. Thus, the unconstitutionality of their little protection scheme has long been apparent, and the executive branch has objected to this for a long time. Carter did. Reagan did. Many others have. Public papers, Reagan brought all that up. And other precedent also opposes this. And by the way, this is not even a close call, okay? Everyone opposes this. It's unconstitutional, and so you got to go. The district court also said, Amy Berman Jackson, in her uneducated opinion, or I would say scam opinion, because it is trying to directly contravene Supreme Court precedent, said that the reason underlying SELA law does not extend to this because the special counsel is special. Well, that analysis gets things backwards, they say. This court's precedents recognizes a general rule of unrestricted removal. And even in Humphrey's executor, that other case that Pam Bondi is not going to be defending anymore, pursuant to an official memo that she sent over to Dick Durbin notifying him about that, said, we're not defending this. This case is crap. The court concluded that Congress could provide, back in 1935, the Congress could provide tenure protections if it was like a body of experts, right? And then they narrowed that down. As long as those didn't exercise any executive power or any other functions. And so what Amy Berman Jackson was doing was trying to squeeze Hampton into this exception, which is a terrible precedent, which I think will be overturned. Second, the court has concluded that Congress could provide tenure protection to inferior officers, but those two exceptions represent the outermost limits of congressional restrictions, even according to the courts. Now, Amy Berman Jackson should not have asked whether the cases applying that general rule should be extended. That's not what she should have asked. Like, should we extend that to special counsel? No. It should have recognized that the rule is the president can remove people at will. That should have ended the matter, especially since the only exceptions to the president's unrestricted removal power are inapt, as in Humphreys, which is the body case, right? That's aggregating a bunch of people into a board. Now, as the district court acknowledged, the special counsel is not entirely analogous to any of this. And so regardless, there's a bright line rule, they say. Adding all of this up, the Constitution prohibits even modest restrictions on the removal power. The district court dismissed SELA law, Amy Berman Jackson, on the ground that no, the special counsel is limited. It's a small subset, doesn't have broad powers. Totally ridiculous. They say Article 2 contains no exception for any of this, exactly. For limited exercises of power for small groups, it's not in there. They just, well, it's not that big. It's the same argument. It's like, well, we shouldn't cancel U.S. aid because it's only 1% of the budget. Well, this is only like 1% of the cases. Doesn't matter. It's not in the law. It's not in the Constitution. It's not in America's interest, so you're done. Saying, as this continues, many other administrations also have said this was a problem. Carter, Bush, but Amy Berman Jackson continues to try to squeeze this in and to shoehorn it in. And the Court of Appeals did not even review this case on the merits. And what's so bad about this is Amy's order does not just stop the president from firing the special counsel, right? The order strips the president of the authority under the statute to even remove him. So what happens if Trump says, okay, that's fine, I'll just fire him for inefficiency. I fired him at will. Now I'll just fire him for inefficiency. She says, no, you can't even do that. He now has his job. The order thus raises the prospect that even if Trump wished to fire him for cause, he would need to ask the court to do that. And that demand for judicial preclearance represents another intrusion onto the executive branch. The first Congress rejected the idea that the president would need to obtain advice and consent to remove someone. No one imagined that they would need to get advice and consent of a federal district court judge named Amy Berman Jackson. So at the Supreme Court, Trump continues, says, having contravened this court's removal precedents, the district court defied the remedial precedents as well. So she shoved him back into the office. Even though they can't do that, she does that, undoes the president's removal decision, stops him from appointing anyone else, and puts him back in office. This court recognized long ago that the court has no jurisdiction of a bill to stop the president from doing his job. But that's exactly what she did. She stopped the president from removing the special counsel. Can't appoint anyone else. Court of Appeals didn't even listen to this, but that is no answer here. All of this is targeting Trump and his constitutional authority to govern this office. Now, whether the order is expressly directed at the president or not, it is violating the separation of powers. And he, if he wanted to complain about this, could have sued for back pay. And all of these cases explain how that works. This one, Weiner, Humphreys, Myers, all of these were suits to recover salary, to recover money, a suit for fees and more. He can go get his money. He doesn't get his office back so he can shred the Constitution. The rule reflects the obvious Article 2 problems that arise if a court tries to reinstate him. The president cannot be compelled to have anybody in there he doesn't want. Indeed, many members of the first Congress said you can't go to the advice and consent of the Senate to remove somebody. And the court is already exceeding its powers. Reinstatement is not a remedy, never has been a remedy. And you can't, all that is, right? You see all these quotes. I fast forward through all the quotes. Here's an example. This case and this case and this case and this case. Tons of other precedents showing that's just not allowed. Now, to be sure, Congress has sometimes departed from that equitable tradition and has empowered courts to award reinstatement. For example, they say, look, sometimes you can reinstate somebody. Like for this, Title VII of the Civil Rights Act said reinstatement could be there. And this over here in Egbert versus this case. And those principles apply to the removal of a municipal officer and apply all the more to the president's removal of a principal executive officer. All right, so we continue. Now, we're unaware of any previous case in which a court ordered reinstatement of a single agency head. Never happened before. At most, what we can find is in 1983, someone effectively removed members of a multi-member U.S. Commission on Civil Rights because that court believed that the commission functioned as a legislative agency. So something totally different. But there's no basis from applying that case to this case. And we're also identifying other factors that warrant relief. Saying plainly, if the Court of Appeals holds that a president may not remove the special counsel, that alone should merit the Supreme Court's review. The court has on several occasions granted cert in heard cases to review the constitutionality of restrictions on the president's removal power. You've heard other cases before showing up on your door. That's why you should hear this one too. Like this one, Collins, Sela, Free Enterprise. Rightly so. The court has recognized that the importance of removal is a tool of supervision, and it is the key means of preserving the executive branch's dependence on the people. The expansion of the federal bureaucracy into new territories the framers could scarcely have imagined only sharpens the duty to make sure the executive branch is accountable. Yes. And further, this court, the Supreme Court, has been appropriately receptive to reviewing cases like this one, where we're seeking aid of the court to protect the executive branch. And that's what we're doing now. Now, what Amy Berman Jackson has done causes extraordinary and irreparable harm to the presidency. A single district judge is forcing the president to continue allowing an officer to exercise executive power when the president, via the people, empowered by the people, thinks that that person should be removed. That sort of harm is transparently irreparable. In the first few weeks of the new administration, the president is being prevented from installing an agency head of the president's choosing to implement his agenda, and the president must instead retain an agency head against his will. Not only can the district court reinstate an agency head exercise executive power without being properly accountable to the president, without, for instance, the threat of removal for unwise enforcement. Now, agency heads control hiring, 100 people plus work there, and the president has lost his ability to implement his agenda completely. Now, the district court faulted the government for failing to identify the reasons. They said, well, Trump should have given us a better reason. That reasoning attacks the notion of removal at will. He doesn't have to give you a reason, Judge. Presidents may remove people for many reasons. To remove those he finds negligent and inefficient, those who exercise their discretion in a way that's not intelligent or wise, people have different views of policy get fired, those who come from competing political parties, if you've lost confidence in someone, you fire people for all sorts of reasons. Then the president is allowed to do that, and it cannot be regulated or by Congress or reviewed by the courts, right? Where the courts come in and they say, well, somebody's going to die somewhere around the world, so we can't allow Trump to do that. Yes, we know, Judge, that's going to happen every day. Like, it's a big world, yeah. But the president makes decisions. He is the president, not you. He gets to decide what the consequences are and whether this is a feasible decision or not you. You're not politically accountable to anybody. All you sit there and do is say, can the president do this thing or not? You don't get to weigh the harms. He's constitutionally allowed to do these things. In cases in which the executive possesses discretion, nothing can be more perfectly clear. His acts are only politically examinable, okay? And if the people are upset, because then their response is, well, Rob, who's going to stop this if something goes bad? Not the courts, as long as the president is acting lawfully. If you have a problem with it because you are freaked out about transgenders not having dance performances in Ireland or whatever, then you can go and speak about that, raise a bunch of attention around your comic book problem, and bring that to the people. And then if the people are upset about it, they'll take that to their representatives, and the representatives can impeach the president. That's the proper check, not the court saying, I'm now the president and I get to substitute my judgment. The district court believes that the executive branch did not face any problems. Oh, well, we're just going to shove him back in your office there and you'll be fine with that. They say that's ridiculous. He can do a bunch of stuff. And finally, the district court also emphasized it's limited, right? So we're going to have another hearing on this on February 26th once this guy has acted as a mole and infiltrated the administration. Trump wants him gone. She wants him back on, right? It's like, you have to be able to pick your team so that somebody's not working in your administration who's going to try to knife you in the throat. The Court of Appeals similarly thought that waiting for 2 weeks is great. That ignores the direct harm. The harm is happening now every minute. The president is elected for 4 years with the mandate of the people to use every minute of that. But in this case, the court has barred the elected president to stop him from controlling an entire department of the executive branch. That action alone raises grave issues of democratic legitimacy and electoral accountability. I don't care if it's limited. No one would be seriously contending that a district court's temporary order stopping the president from issuing a pardon or making a nomination or recognizing a foreign sovereign would be allowed because it's only stopping the president for 2 weeks. That's happening here too. Well, you just can't be the commander in chief for 2 weeks. You just can't be the president and go do this thing for 2 weeks. That's ridiculous. Indeed, history and precedent underscores the president and the nation's interest in prompt removals. The framers deemed an energetic executive essential to the protection of the community against foreign attacks, the steady administration of laws, the protection of property, liberty. Accordingly, though they chose not to bog down the executive with habitual feebleness or dilatoriness that comes with a diversity of views and opinions. Well, we need multiple people there to hold them accountable. No, that's what Congress is for. Very diverse, very representative of all the things. And it's a disaster. We need stuff to get done. So you don't need to have a bunch of people who are going to be knifing other administration officials in the back. Instead, they gave them decision, activity, secrecy, and dispatch. so they can get stuff done. Now, consistent with that history, the court has recognized that sudden removals are sometimes necessary. 1879 case. The moment that a president loses confidence, he must have the power to remove him without delay. Myers, 1879. In that case, the court cited the prospect of delay as one of the reasons for holding that Congress could not require the Senate's consent for a removal. Yeah, right, because if the Senate has to weigh it, they're just going to schedule it out far, far out, and you'll have a mole embedded in the administration. The court's precedents foreclose that from happening, and we're not going to allow that here, Judge. The district court's order also threatens harm to the office of the special counsel, saying if the president had attempted to remove him, there was probably a reason for doing that, and the prospect of mass invalidation of everything done, right? Once he leaves now, like, she shoved him back in, everything he's touching now is going to be tainted, and so it's actually harming the office. His appropriate remedy would be to just ask for back pay. Now, granting the government relief would not cause any harm to him. He's been removed, but he's not entitled to his job or salary. That's not irreparable injury. His reputation is not irreparable. Thus, the traditional remedy of this is for back pay. Now, the district court determined that his removal irreparably harms him because he can't do his job. But this court has rejected that reasoning too. Loss of salary is not judicially cognizable. Loss of power is not. Loss of salary is judicially cognizable, but loss of power is not. The notion that public officials have a separate private right, like a property right, to their office is an alien concept. They're not entitled to it forever. At bottom, respondents' claim to irreparable injury from being unable to continue his job is the problem. Executive power is the president's, not his. He doesn't have entitlement to the job because he wasn't elected president. If he wants it back, he can go run for president. And so you can hear this case. You can hear it, okay? We can take this right to your court. The All Writs Act says Supreme Court. You can hear it. Also, the Court of Appeals has jurisdiction over the government's appeal under this provision of the law. And so this is jurisdictional stuff, less interesting. But although Amy Berman Jackson labeled her decision a TRO, it is actually a preliminary injunction. And they already tried their administrative stay, and then they conceded that was a TRO, okay? So she called it a stay so she could label the second proceeding a TRO. But the first thing was actually a TRO. So the second thing is a preliminary injunction. And so since we're here, we should be able to be in front of you. The court received adversarial briefing. It was sufficiently extensive. So now this is properly matured and it's knocking at your door, right? And the people on this in the Supreme Court who I think are problematic here would be like Amy Berman Jackson, because I think this is one of her issues. She likes stuff to go through the proper appellate process. Okay, we saw that even with the Trump sentencing case, which is obviously mostly mooted now because he got no sentence ultimately. But that will still work its way through the appeals, right? But rather than the Supreme Court accepting it immediately, she wanted to wait. But that's a different case because that was a private defendant litigant, essentially, charged with a crime based on the time of the charge, even though he was the president when, or elected to be the president when he was getting sentenced. This is different, right? Because now he is the president and this is an executive power that they're impinging upon. So maybe she accepts it. I don't know. I hope the court accepts it, even if it's a small, majority. Anyways, let's see. Smaller majority without Amy. I think Roberts is the one who's going to be more inclined to accept it. Anyways, so this case, moreover, involves the president. Here it is. The president, or in some cases, the vice president, is often able to obtain immediate appellate review, unavailable to ordinary people. Okay, so that's actually the distinction right there. That Trump was just a regular civilian when he was being sentenced in New York, but now he's the president. So, Amy, accept this. The court and the precedent thus recognize that interlocutory review is sometimes necessary to protect the executive branch. Consistent with these principles, you should take it. Finally, the government asked the Court of Appeals in the alternative for a writ of mandamus. The district court's extraordinary order satisfies that, so there's jurisdiction if we go that route. The Court of Appeals also raised the concern about bad precedent, so you can settle that. Now, this case involves an order that runs against the president, and the president is not, quote, many litigants. Okay, so you don't have to worry about that. Now, Chief Justice Marshall long ago explained that in no case would a court be required to proceed against the president as an ordinary individual. Not only that, the order trenches on two of the president's conclusive and preclusive powers, the power to remove and the power to oversee prosecutions. That's at the core of his power, and they're infringing on that. Now, the government's response so far in this administration underscores the distinctiveness of this case. As noted, in the weeks since Trump's current term began, district courts, mostly in D.C., have issued multiple TROs that block the president's policies throughout the nation, sometimes even throughout the world. Although the government firmly believes that these TROs exceed their lawful authorities, it has thus far sought the court's intervention only in this case because this TRO intrudes so deeply into the Article 2 powers, right? They're waiting for the best case to take up. They're going up on this one. The Court of Appeals also overlooked Hampton's own litigation conduct. Instead of awaiting the district court's judgment on his back pay claim, as many other removed officials have done, he sought a preliminary injunction because he needed to get access to those emails again. Not only that, he had obtained an administrative stay hours after he sued and a TRO 2 days later. Respondent was thus the one who created this emergency, and he cannot credibly claim that his interest in seizing the office from the presidency is urgent enough to justify the relief by the court, but that the elected president's interest in taking the department back is insufficiently urgent to justify relief. Now, if anything, it is the denial of this application. If you don't hear the Supreme Court, that would set problematic precedent. The Court of Appeals below us should have heard it too. Why? Because for apparently the first time ever, a federal court has issued an injunction preventing the president from removing an agency head and filling it with someone else. Leaving that order in place would suggest that district courts can, without appellate review, stymie any of the president's exclusive Article 2 powers for up to 28 days. Where'd that number come from? 28 days at maximum, and maybe longer. Now, of course, federal courts have an institutional interest in the orderly consideration of cases, but the executive branch has institutional interest too. Here, the president has an interest in his exclusive power to remove and fire people, so he can put his policies in place. The district court has frustrated those interests in a way that manifestly violates the Constitution and defies this court's precedents. And so this order should not be allowed to remain in place, not even for one more day, not much less 2 weeks. And so Sarah Harris says to the Supreme Court of the United States, this court should vacate Amy Berman Jackson's lower level TRO/administrative stay and granted the motion for Hampton Dellinger. Get rid of it, delete it, so the firing can be effective. In addition, the acting solicitor general respectfully requests an immediate administrative stay of the order pending the court's consideration of this application. So 2 requests there. Get rid of it permanently, right? Just deny it, vacate it. But also, while you're considering this, like, and actually mulling this over, how about you just stay it right now so that we can kick this guy back out and turn off his emails, as he undoubtedly is rummaging through right now to clean out the wreckage. So that is Trump's brief to the Supreme Court of these United States. You can see, we'll skip the scrolling, go all the way back up to the top. In the case of Scott Bessent versus Hampton Dellinger, and this is now out of Amy Berman Jackson's hands, out of the Court of Appeals' hands, and we'll keep our eye on what SCOTUS says. We'll have more briefings, more deadlines. Thanks for subscribing and joining as we keep our eye on this one and many others. All right, and so good update on that one. Now, let's turn our attention over to Doge, because we had an interesting hearing that took place today, courtesy of our friend Margot Cleveland. And so let's get right into this. Is the DC District Court caving on the Doge lawsuits? That's the question that we're going to get into in this video coming up right now. Judge Chutkan seemingly caving on the Doge lawsuits. She had oral arguments today in her courtroom in the District of Columbia. And you can see the case here is the state of New Mexico versus Elon Musk. Now, it's not just New Mexico. It's a bunch of other states. They all gobbled together here, and they filed this lawsuit. This is from the original complaint. It's a 64-pager. It's basically saying Elon's a bad guy, and we don't want him involved in the administration. Like, that's what they're asking. Cut off Elon. And normally we're looking at the lawyers who are filing the suits, like Norm Eisen or Mark Elias's group. But these are state AGs, bunch of them. Mexico, New Mexico, Arizona, Michigan, California, Connecticut, Hawaii, Maryland, Massachusetts, Minnesota, many others. They are all suing, as you can see, Elon Musk, Doge, and Trump, all getting sued. Now, Trump's DOJ responded, and there was a hearing on this today. Here is Trump's 7-page response before we get into the proceedings. Trump's DOJ says, look, all right, come on, District Court, District of Columbia. Judge Chutkan is presiding over this one. And we remember who Judge Chutkan is. This woman here who was very involved in Trump's January 6th case and that prosecution out of D.C. This is Michelle Lujan, the New Mexico governor who tried to ban the Second Amendment via executive order like a moron. And essentially, the lawyers are the attorney generals. Okay, so no real funny money that is being poured into this particular lawsuit. But here is what Trump's people say in response. They say the state's overnight rewrite of their requested relief that you asked them to fix only confirms the basic fault with this emergency motion. The states, Judge Chutkan, cannot identify any imminent, irreparable harm that merits this court's intervention. They want Elon cut off, thrown out. There's nothing there that justifies that. So this court should deny the state's second draft. It is exceedingly broad, reaching so far as to all of those, quote, acting in active concert with Elon. Like they want the order to embody everybody. And even anyone affiliated with Doge, which could include the president, Senate-confirmed officials, a host of other government officials as well, saying you need to cut them off. And it fails to provide Trump with any notice of fair terms. It seeks to enjoin Trump from accessing, they say, any data system. It's what they're asking for. That's included but not limited to confidential information, personnel data at various agencies. But nevertheless, so this is like insane what they're asking of you. Nevertheless, we request that if this court is inclined to grant any of that, the court hold a hearing on Monday and allow us to brief this. Here's why. First, the states and their data access related claims are fundamentally disconnected from their legal theories, just like their brains to reality. The states have not raised any claim under the Privacy Act or any related statute that is actually challenging Doge's access to data. Instead, the states have primarily pressed an appointments clause claim, saying Elon's not properly appointed, along with a related statutory claim, which is wholly unsupported, and in reality false about these authority assertions. We don't even have these things. So like you're basing your lawsuit on a bunch of fake news that doesn't even exist. So we can't even really address this because your claims are just so illogical. But they say, look, all right, their legal theories are nuts. But even taking the state's legal theories as correct, they still offer no basis for emergency relief. Like, why would we cancel Elon from all of this? Even if they're right. Even if Elon were an improperly appointed officer, which he's not, there is no constitutional defect to sharing information with him, any different than there would be with a private citizen or an unauthorized employee. Now, to be sure, that may well run afoul of other discrete laws, but that's not what the state is litigating now. Okay, so like you might say Elon getting access to that data or whatever is illegal, but you got to show us like what law, what piece of data was violating some record or something, right? And in theory, just think about this in practice. Like Elon doesn't even need to have access to the data. Like he doesn't need to go in and see the records or any of that. He can have somebody who is authorized to go see those records come in and say, hey, this is what I found. Okay, when you were auditing Social Security, what'd you find? Well, I found that this is what's happening. Elon posted this. So go audit Social Security. Says, okay, this is what I found. These are the numbers of people in each age bucket with death field set to false. Okay, so 0 to 9, 38 people. 10 to 19, 44 million, 20 to 29, 30 to 39, 40 to 49, 47 million people alive, right? Probably current alive with these social security numbers. But apparently when you keep going, we have 4.7 million people who are alive in the age range of 100 to 109. We got 3.6 million who are 110 to 119 years old. 120 to 129, 3.4 million people. Amazing. 1.3 million people are between 150 years old and 159 years old. Okay, great. So the point is, like, Elon is not going in there and looking at each individual record and getting information on 170-year-old, Granny Susie or whatever. But the person who is gathering this data and assembling this data has that information. So Elon Musk, just like a chief of staff like Susie Wiles or anybody else like Ron Klain, who's not appointed or confirmed by the Senate, who just works with the president, he can then interpret this, go, holy crap. Hey, Mr. President, we found a problem. Seems like there's like 15 million people who are over 110 years old. Okay, so we should do something about that, right? So let's do it. So then Elon can just send the people back with the actual authority to go look at the records again. So he's just analyzing data like a consultant would, essentially, not accessing anything that's even controversial other than the data. But if you're saying he violated something else, well, then go find it. Go prove that. Make your claim. Sue for that. But you're not suing for that right now. As for the employees of USDS who may have access to agency information, the state cites nothing for the proposition that every action by every employee of an agency that is headed by an improperly appointed official is somehow unlawful, nor could they. That's because an appointments clause defect runs to the actions of the improperly constituted officer. It doesn't invalidate every act of the subordinates, citing a different case. Now, as fundamental, there is a basic mismatch between the actions the state have chosen to focus on, which is data access. Now they're just trying to shut the data off. And the essence of their legal theories. Both claims, the constitutional one, that Elon is unlawfully appointed, and its statutory counterpart, which is that Elon's violating the law, accessing things, they both rest on Elon Musk and USDS, Doge service, having the authority to make decisions for the US government. They rely on that. But the premise is wrong. It rests entirely on conflating influence and authority. They're different. An advisor does not become an officer simply because the officer listens to his advice. Okay, Elon might talk to Treasury. Elon might talk to Marco. Elon might talk to somebody else. The officer is doing the thing. He's influenced the authority. The authority is actually doing the changes. And if you strip all of this of their lengthy rhetoric, the states, the government, in their ranting little complaint, they do not cite a single example, not one, where Elon Musk or anyone at Doge has been given formal authority to exercise the sovereign power of the United States. Can you give us one example? Or are you guys just crying about, what's he accessing? No one knows our data. Huh? Relax. What is your point? The states and their sparse examples prove the point, okay? It's all hysterics. Their best, in fact, only example of any tangible action, even affecting the states, is a single pause grant from USAID, which I thought was foreign money. Why are the states getting that? But as is well documented in parallel litigation happening in other courts within this district, those decisions were made by properly named officers at the USAID. They were officers who were ultimately acting pursuant to executive authority that came from the president, not from Elon, anywhere. Nowhere is there any government action taken in the name of Doge or by an officer in conflict with the appointments clause, okay? And this is why they're going to have a real tough time slowing this thing down, because it's just information. Okay, Elon is banned from accessing anything. Okay, that's fine. He's just having phone calls with people and just saying, well, you know, if I were running the government, I would have a problem with having 15 million people over the age of 110 or whatever. Maybe we should look into that, right? It's always just going to be about information and productivity ultimately, and they're going to have a hard time stopping that. But they have to sue everybody, right? And injunction everybody from getting advice and from counseling, like Elon's going to be barricaded, but locked in a cell somewhere. But even if the state's premise is right, and Elon and Doge has been tasked with wielding some sovereign power in some way, that has nothing to do with data access, which does not involve any exercise of authority at all. It's a purely internal act of government. So you're going to say we can't access data, our government, like at the Treasury or anywhere. Again, the states are free to litigate that such access violates some other source of law, as they brought those claims in other courts, but the claims that they have chosen to press here turn exclusively on the improper exercise of authority. They're saying you can't do these things. We're saying Elon's not doing them. So what's your problem? And there is no exercise of governmental power against the states from the mere access of data, right? He's just looking at things, which is by definition a preparatory step to inform some later action. And second, the states and their ad hoc categorical relief, which means they want to enjoin anyone who is acting in concert with Doge, like everybody who even is on Doge's email lists, you're banned. With Doge from accessing virtually any agency data, it's too sweeping. It's not even connected to any immediate harm to the states, and it's completely unjustified. When an agency shares data with others, the propriety of that decision will turn on the specific facts of how the information is shared and the statutes governing the agency. That is why, until at least now, data access cases have been litigated on an agency-by-agency basis, where courts have either denied relief or at least attempted to tailor it to the actual dispute. You don't get to just come in here as 14 different states and say they can't do anything in the government because we're upset that something bad might possibly happen. The state's approach seeks to pretermit these other cases and just order widespread prophylactic remedies on exceedingly vague grounds, but without the sort of particularized claims that they need for an emergency relief. Like, if it's an emergency, you got to explain why it's an emergency, and it better be one. A federal court, however, cannot proactively enjoin an entire class of conduct by the president on the ground that some future conduct may be unlawful and may affect the parties before it, especially now with the TRO. And all the more so, given that particularized legal questions that the states ask this court all come in under one fell swoop. They're asking for everything. These data access cases often concern detailees from Doge, controlled and supervised by another agency. Now, the states make no effort to explain why that is unlawful. How? What's wrong with that? None of this is to say the court should proactively bless these practices, but by the same token, it cannot proactively enjoin them either. We need a particularized dispute. But this is general assertions, and there's no tether to any actual illegality. And again, none of this, say Trump's DOJ, none of this has much to do with the actual claims even pressed here. Even assuming the states are right on their legal theories, and they're very much not, then Elon and Doge employees are effectively private citizens if they were right. Because any authority they purport to wield would have been void ab initio from the beginning. But even then, there would be a separate dispute about when an agency can share its own data with such persons, which is a hypothetical dispute, hasn't even happened, that is entirely unbriefed and wholly speculative, given the states chose to litigate an entirely different case. And third, the states' claims regarding their personnel decisions are even more flawed. Wow, all these AGs are just so dumb, including Chris Mays from Arizona, moron. Again, even accepting the states' deeply wrong legal theories, Chris Mays, nothing here would warrant emergency TRO relief. As the court recognized during the TRO hearing, personnel decisions are not irreparable. Employees may be reinstated and back pay may be awarded, consistent with the statutes. Further, the connection between these decisions, turning on the notion that Musk or Doge may take certain employee actions and may have some potential consequences, is way too hypothetical. We can't talk about that at a TRO, Judge. You're going to limit the executive branch because something may happen possibly at some time in the future. And fourth, the proper course of action is to just schedule this for a preliminary injunction. We want this court to convert the state's motion for a TRO into a preliminary injunction, set prompt briefings here. We take no position on when their response should be due, but we'll get ours in. And finally, we request that any injunctive relief, if you are going to hamstring the executive branch, Judge Chutkan, stay it so that we can appeal it for 7 days. And you should also require an injunction bond. Yes, I'm very happy to see this now introduced. Injunction bond. Okay, this is the idea that the suing party should put up a bond, should put some type of security up to compensate the government for the lost productivity of workers wrongly enjoined. which the states do not even acknowledge, let alone justify excusing here. Okay, so if the states win, then a bunch of employees from Doge and Elon, all this work comes to a grinding halt pending the litigation. Okay, if you want that to happen, well, why should we pay for that crap as the public, federal taxpayer? If the blue states want to bring these claims, they can come up with their money, post a bond, so that the federal government doesn't come out of pocket for these types of damages. And this, I think, would stop, okay? If they actually got these, and if they start requesting these, then guys like Norm Eisen, guys like Mark Elias, who are launching these lawsuits with their big law firms called Perkins Coie, where Mark Elias used to work, all bringing their lawsuits. If they had to put up some money saying, oh, you guys can't stop the USAID funding. We're stopping it because there's fraud going out to the tunes of billions of dollars. So if you're asking us to turn off the fraud spigot, then you're responsible for the fraud if we win this lawsuit. And so why don't you post a bond to the tune of $65 billion a year? And then we'll turn off the floodgates, because if you lose and we win, then we can recoup our damages from your $65 billion bond. So that would stop a lot of it, because they don't have the money to put up those lawsuits, and the federal judges would be stalled out on that. But now, with all of that said, that was Trump's DOJ submitting their response in Judge Chutkan's courtroom. Now let's go to the proceeding that took place today, courtesy of Margot Cleveland. Highly recommend you follow her work at The Federalist and on X at Prof. MJC Cleveland. Professor MJ Cleveland in the house. Go give her a follow. You know where to find her, and we'll repost this so it's easy on our timeline. She was listening to the hearing today and reported on what's happening as follows. She writes, Judge Chutkan comes out, court is in session. All rise. Please be seated. Judge says, all right, good morning. I know it's President's Day, and I know we just had a hearing on Friday, but I did ask the plaintiffs here to file a proposed order and to narrow the terms of their request. So in other words, the state should go back, stop asking for everything. She's like, I can't order Trump to resign. Okay, sorry. So just narrow that up a little bit. Come back to me with something else. They did file their narrowing motion on Saturday at 4. Now at Friday's hearing, the judge said, it was my harm. And I was asking about harm and whether it was extremely serious and whether there was a colorable claim. So states explain what this harm is, what's so damaging to you. But the TRO and the one that they were proposing, it wasn't narrowly tailored to the government. So they narrowed it from the 11 to 2 department. I asked that it be revised, and so they did revise it. They came back, this is Judge Chutkan speaking, and they said we want to enjoin Musk, we want to enjoin Doge, we want to enjoin the defendants and any accessing or copying of these 7 agencies, and terminate agencies in employment. Don't let them fire anybody. So the states came back. They said, don't let them fire OPM. Don't let them fire education, labor, HHS, transportation, commerce. Okay. So the states came back and they asked for everything. The judge says, I can't take control of the executive branch. They say, okay, here, let's narrow this. How about you just take control of 7 agencies, the biggest ones, OPM, education, labor, homeland, HHS, energy, and more. Ridiculous. Now, they asked for 14 days. Say, stall them out for 14 days. So the funds can be evaporated and the grift can be deleted. They say, Your Honor, we need this. Okay, here's why. There's a declaration. We submitted a bunch of declarations. There's news reports. And there's going to be a lot of harm if these agencies have firings. And Doge is coming into the next ones. They're coming to get everybody. Trump's DOJ responds, Your Honor, this is way too broad. It's not even tied to the appointments clause at all. Their original lawsuit was about the appointment clause, and Elon is unlawfully appointed. So it's not even appropriate. So we would ask to proceed to a preliminary injunction. And at 1:30 a.m., they filed their reply, and then they added in a new claim. Now they're crying about data disclosure and how dismantling these agencies will cause irreparable harm and blah, blah, blah. And they oppose the preliminary injunction and they seek discovery. Now on Friday, there were TROs, and the TRO's purpose was to preserve the status quo. And so the same part test, the TRO, there's kind of those four things they analyze: irreparable harm, public interest, and two other relevant factors. Emergency TROs are so imminent. And if we get to a preliminary injunction, then can we allow discovery? So the states say, look, we're confident, Your Honor, we have evidence necessary to get the restraining order. The judge says, yeah, I know you say that, but there's a lot of news reports out there. And Judge Chutkan is speaking, says, the court can't act based on news reports. The news reports aren't the basis for a TRO. So like, what is happening to you specifically? The states say, well, I can already point to what has already happened and a lot of stuff, like we're losing our money. And Your Honor, we have absolutely narrowed our request. Our main concern now is how they are using the data. Are they using the data for purposes other than it was designed to be collected for? It's ridiculous. You can only look at the spreadsheet if you're looking for these, but not looking for that. Okay, judge says, well, how does that tie to the complaint? So like you filed a complaint. This is why we're here. There's no data complaint materials in your complaint. So what is this? Well, Musk was posting about this, Judge. He posted about this on X. He posted about Doge, and he created a bunch of Doge websites, and he's looking at everything, workforce, regulations, and finance, and he's using data they have to access the information and to decide how to make cuts. So the Department of Education, they already are noting there's a shortage of educators. They say there's going to be poor outcomes and more. The state's lawyers just like begging. They are relying on this money for operational and technical support. And so why is that being threatened by Doge? Or judge says, well, what is being threatened by Doge? Like, what are they going to take from the Department of Ed? What are they going to take? States say, well, Doge has affected funding cuts across everything: education, research. Here's one example, Judge. The Institute of Educational Science, whatever the hell that is, okay? The Institute of Educational Science, it sounds fake, have in the past studied programs used in New Mexico. The judge says, well, if I don't issue the restraining order and if I convert it to a preliminary injunction and you win, what happens? If it gets slashed and you can't get the money, what happens? Well, he says cuts to nuclear are hurting New Mexico. Well, we're getting reports to Doge that they called for cuts to CDC, says New Mexico. They're going to be cutting Indian health staff. It was just made public. In fact, the new secretary is going to try to rehire some people. New Mexico has a large tribe. And the judge says, okay. But what I need for this, for a TRO, the judge is saying, like, that all sounds bad, fine. But it has to be extreme harm. Like, it has to be imminent. Like tomorrow. And it's going to definitely happen. So like, you're talking about all this stuff, but it's kind of theoretical. Like, where's the actual harm happening now? A TRO, says the judge, Judge Chutkan, by the way, is like not buying it, says something that can't be undone, right? Difficult or challenging, but it can be undone. Like this, it can't be undone. Like that's why we're here. The judge says, Judge Chutkan. And so, generalized fear, like if you're afraid of this, even if it is likely, it isn't enough for a TRO. And I'm not seeing it so far. What? This is Judge Chutkan? The state says, oh my gosh, Your Honor, if Trump has evidence to refute this, then he can refute this. And Margot is pointing this out. That's not their job, the defendant's job. That's called burden shifting. Shifting the burden to them. You filed the complaint there, bucko. State AGs. You bring the evidence. Not up to Trump. He's not breaking the law. You have to prove that he is. Judge says, citing to the Washington Post and their article about Doge memos and the spending cuts, he's showing this. Your Honor, the Washington Post, look. And on Wednesday, they're going to start with staffing cuts. It's not just being described. The judge must have rolled her eyes. Says, I understand your frustration. The state's references X posts of education's next, right? Elon's like, we're coming for education. He's like, see, Judge, you're going to come for us. So they want Your Honor to create a TRO based on the agencies and on what has been targeted. The judge says, well, there's a bunch of other cases like this case, and Judge Chutkan is reading in this case. Why can't the states get a TRO in 2 days? Like if it's happening on Wednesday, then come back here on Wednesday. Like come back here tomorrow or on Wednesday. Like it hasn't happened yet. So right now, this is a prophylactic TRO. That's not allowed. I'm not allowed to do that. The states say, well, Your Honor, but going back to the Washington Post, there's a Doge memo saying all agencies will be targeted. And we got a video on that coming out later tonight. Between Doge memos, statements, and ex posts on Wednesday, we're going to see even more. They're going to slash and burn everything. Doge Phase 3, it's what it's called. This is the appointment clause claim. It's different than any other TROs, and our request is dramatically different because we aren't seeking to enjoin agencies. It's just Musk and Doge. They don't want them to get the info because if they get info, then they can direct the other agencies on how to make the cuts, and the agencies are making the cuts. Well, the judge says, look, I want to look at the relief that you're asking for here. What is the harm if they have access to the information? Like, how is the information going to be directed to the harm of you? Well, it's the use of the data, they say, the states. How they identify and how they make cuts is through the access to the data. So like if we stop them from seeing the data, then they can't find the fraud or the useless bureaucrats and fire them. The judge says, but isn't it in Doge's remit, in their authority? Like, isn't that what they do? Like, isn't that what the whole agency is for? Is to analyze data that Obama made? Also, if it already happened, then it's not imminent. Like, it's not going to be happening imminently. So, like, did they already get the data or what? Well, yeah, Your Honor, they were charged with rooting out waste, but these are not advisors based on statements. It is clear that CMS directions where to cut were from Doge and Musk. And they're only able to do that through the analysis of the data. Okay, so all the liberals are like, let's get rid of the data. Giving directives is well beyond the executive order. The judge says, look, again, that's fine. All that's okay. But you are here for a TRO. You also want to stop all personnel decisions, right? Now, how does this cause harm? Like, if they make personnel decisions, it's harming you? Well, Your Honor, like they're making major personnel decisions. The only place for safe disposal of nuclear waste, right, and energy, they issued a notice to terminate personnel. And that includes staff who oversee disposals. And so we're all going to have radioactive material burning and corroding through our veins because of Trump and Doge. Oh, no. Maybe we can all be Spider-Man. Wouldn't those employees have the claim, right? The judge is like, well, why are you complaining about that? Like, if these employees got fired, shouldn't they be suing? Like, why are you here? Well, our harm, Your Honor, is the state's ability to carry out its function. Loss of administration personnel, there's no one to pick up the phone or to write the checks, and so we're all going to die. Yeah, but the judge says, okay, but TRO actions and OMB access, these are different claims. These are privacy claims. These are other claims. Why wouldn't those other cases provide relief that bars access to the data? Like there's other cases, people are suing over firing and the Judge Cooper and the Judge Bates case. The states say, well, those were Privacy Act claims. Now, we want to make sure Musk and Doge aren't using data inappropriately, whatever that is. Okay, but the harm you are alleging, state, is already being considered in other cases, and it's still broad. You want 7 large agencies to not share data and to not fire anybody? 7 agencies? What? Yes, say the states, because relief has not been issued yet. There's a difference between enjoining an agency and enjoining Musk and Doge, so just go after Musk and Doge. That is the significant distinction. Okay, but if there's imminent harm, says the judge, wouldn't the harm be to the Department of Transportation and to the Department of Commerce? What would it be? And what would it be to the states? Like, how would you guys be harmed? Plaintiff is the state's kind of just running her mouth. I guess it's a woman saying inability to carry out the programs and the functions, Your Honor. It's just like a lot of stuff like can't work. Judge asks the team, the government, about Musk. Well, tell me about these reports of like 1,000 people. Okay, DOJ, Trump's DOJ, you're next. Tell us about these reports of like 1,000 people who got termination notices. Is that true? Your Honor, I can't confirm if it's been 1,000 or what. The judge says, wait a minute. What? You can't like tell us if that's happened or not? It's not a small thing. It's 1,000 people who got fired. You haven't looked at it? Well, I looked to what was relevant, Your Honor. That's why we're here. I'll look at it. Yeah. And again, this is the judge like, it's not your prerogative. Like, that's a lot of people who got fired. Yeah, that's Trump's prerogative. He's allowed to fire them. It's his branch, not yours. You can be sad for them, but it's not even relevant at all to this. He can fire 10,000 if he wants to. And are additional terminations planned in the next 14 days? I can't base what we're talking about on news reports, but you should be able to say we fired and we will be firing X more. Like the judge is like, well, that's what I would be expecting. Government prosecutor from the DOJ says, well, Your Honor, starting with the state declaration to justify imminent injury, only 3 states here today are even discussing data access and concerns by the resident. That's it. There's like 14 states here. Only 3 are talking about data. New Mexico says it has data at 3 agencies. So it's like, well, we got some there and there and there. Now they say that the concern is not the access, so the TRO shouldn't be able to address it. Now all discuss possible actions that may affect downstream, but that's not imminent. So this guy's going through the complaint saying, here's what they're upset about. But okay, there's some data at some agencies, not all 7 of them. Like New Mexico has some in 3, but like that's not even, okay. And they're not even complaining about it. And the harm is not even direct. So I don't even know why we're here. The judge says, well, the reason that language is used is because Doge actions have been unpredictable and scattershot. No, they have not. They've been very predictable. They're just shocking to you people who thought you had permanent grift ensconced in the federal government. Now, while will there be terminations, or will there be? Your Honor, look, I can't speak to that. But the basic point here is that Musk or Doge is exercising, they say, power without authority, right? That's what they say. I don't even know what they're complaining about, terminations, hiring. We don't know. They say Musk or Doge is acting without authority. But all the actions that they complained about, that they wrote on paper in their complaint, there is a paper trail. They're all there. Now, what is clear is that you have a properly named officer exercising his authority at every one of these decisions. There is no evidence that has been presented here, Judge, of Musk or Doge doing the terminating. Okay, never even been presented. So I don't know what they're talking about. Judge says, well, Musk hasn't been appointed or confirmed. Yeah. So he's essentially a private citizen, right? To fire, hire, contract, terminate. He's doing that all without congressional approval, right? So he's like running wild. Your Honor, he is a special government employee. Their theory is that Musk exercises authoritative influence. Now that is not an appointment clause claim. Influence is not a claim. They have not shown any formal or actual authority to make any decision himself at all. They haven't shown it. The judge says, well, I think you're going a bit too far here. No, Judge. Has the state marshaled any evidence of imminent harm? Have they shown that? The judge says, well, can the government agree to just hold off on mass terminations while the preliminary injunction is litigated? Can you just agree to hold off on firing everybody? I mean, if you don't do that, like, what's the harm? Like, what's the harm if you just keep these people employed? Can you just not fire them, please? The judge says. Government says, what? I can't make that commitment, Judge. Agency heads have the authority to manage their workplace. Well, she says, but the allegation is that Doge is directing the terminations, and they're accessing data and firing people and terminating the contract. They're essentially running the government. Well, Judge, if they're saying that, that's fine. They can say it, but they need evidence to back it up. And it would be easy to find, okay, if this happened. Someone is exercising power, and they can't show that someone isn't a person with power. It's the Treasury head. It's Interior. It's Rubio. So all they have to do is identify who was fired. Where did the authority come from the firing? It came from the agency heads. So the states haven't done or shown anything saying that they are just puppet strings. The judge says, shoot, it's a pretty good argument. Crap. So you're going to fire everybody? All right. So, all right, states. Has the court, ever granted a TRO regarding the appointment clause? She's like, can I stop somebody from not being properly appointed? States say, I'd have to confirm on that one, Judge. I don't really know. The judge says, no, there aren't. Okay. I haven't found any. This is factually a one-of-a-kind situation because they're suing Trump for running the government. Like nobody has ever been so dumb before, stupid states, but here you are. There may not be a TRO issued, but we've never experienced this type of wielding of power, says the judge. Our papers speak for themselves on points the government made. Okay, this is probably the plaintiff saying this. Okay, so, okay, judge says, no, I haven't found any. So then it's probably the lawyers who are saying, well, judge, our papers speak for themselves. Okay, just because there haven't been one, we've never had a Doge before. You may have never had the firings before, but there are firings, and the firings are part of the power. Just because you do a lot of the firings doesn't make them unconstitutional. The one firing is constitutional. Multiply it times 10,000 or 50,000 or 100,000. It's the same power, just at scale. They haven't experienced that, but now they're getting a taste. So the states say, Your Honor, we're seeking here to restrain Doge and Musk. We don't want to restrain the agencies. If they don't have authority, then it won't hurt the agencies, okay? Because they don't have the right to fire these people anyways. The judge says, all right. Thank you all for coming in and making yourself available. I will rule on the motion for TRO and issue further scheduling. I hope to get that out in 24 hours. If you have to come for the injunction briefing, what are you proposing? Let us know. Meet with the government attorneys and work this out and let us know. Margot says, having shared all of this with us, thank you, Margot, for the report. My gut, she says, is the court is going to now deny the TRO and convert it to a preliminary injunction. We'll have another hearing and more evidence presented. So, very nice report and a good filing from the Trump DOJ and a good showing in court, right? They're not even entertaining. What I like about this is they're not even entertaining the judge's hystericism. Can you slow down the firings? No. Can you promise you're not going to do? No. Why didn't you understand how many people you're going to fire? I don't need to. It's my business who we fire, not yours. And Judge Chutkan is going to have to be dealing with that accordingly. So we'll wait for her ruling. Let's see if there's anything that dropped today in the final minutes, if anything came out of her courtroom. And nothing yet. So we'll come back on that one, of course, tomorrow, and we'll see what the latest is there. But meanwhile, this is the reaction to Elon's continual winning. You can hear what this sounds like all across America from the Doge team. Yeah. Good work, Elon. Keep it up. All right, so that's happening. We also saw Elon post about this, saying, according to the Social Security database, these are the numbers of people in each age bucket with the death field set to false. And we ran through that earlier in the segment, but the numbers are pretty shocking. Now, what we saw is Fetterman came out and he said, you're so stupid. He said, I want to save billions of your money and make our government more efficient. Right. Says rummaging through your personal crap. And the Democrats are trying this as a new strategy now. They're trying to use profanity to think they think it makes them like hip with the kids and the youth of America or something. He says this is a party of chaos, loses always. And I don't know, maybe he knows something about that because their party just lost. But Elon says, bruh, look, if I wanted to rummage through random personal crap, I could have done that at PayPal. Hello. Or X. Hello. Or Tesla. Hello. Having tens of millions of people marked in Social Security as alive when they're obviously dead is a huge problem. Obviously. Some of these people would have been alive before America existed. And so think about that for a second, Fetterman. Now, similarly, we have people from USAID and other entities that are having a tough time here. And this is one report here from our friend Steve Friend. FBI whistleblower suspended for blowing the whistle. He was sharing this 60 Minutes clip, and they're just very upset about their jobs all being gone overnight. I know how hard it is. I remember when they were shutting down our businesses for multiple years and then lecturing us saying we deserved a winter of misery or death because we were non-essential. I remember all of that. Yeah, it was a horrific time. So we have very little empathy for these folks, but here's what they sound like on 60 Minutes.
People are really scared. I think that, 12 days ago, people knew where their next paycheck was coming from. They knew how they were going to pay for their kids' daycare, their medical bills, and then all gone overnight.
All gone overnight for Christina Dry and Adam Dubard, fired this month in the chaotic shutdown of foreign aid.
Okay, so a very terrible situation here. They do little stupid voiceovers that nobody cares about. Here's them.
They're not looking for competency. They're not looking for if you're good at your job. They're looking for pure loyalty tests. And if you don't give it,
Do you mean like what you guys did when you fired everybody who didn't take the jab? or who didn't acquiesce to the demands of the CDC state?
You will be punished.
And they had to leave the building. And these are folks who
Good.
had decades and decades of public service.
Public service, it's called a job. Everybody else shows up to their job and gets paid for doing work. They are civil servants who do civil service work for decades, grifting and living a life where they never get fired and they get tons of benefits every day off, all this special stuff. It's ridiculous.
Serving USAID across administrations, from, George Bush to Obama to the first Trump administration. And they were never able to walk back in the building again.
Bye.
There was no
Good riddance. Don't come back. Adios. So good stuff there. Now, we also saw this clip here from our friend Brooke Taylor, who clipped this one for us. And she reports for Fox News. She was saying, look at how much money and grift was going out. It was an insane amount. It says a new government watchdog group reports that HHS, RFK Jr. is going to be taking over that soon, spent $22 billion on migrants over the last few years. And it's like loans to repair credit scores. Unaccompanied minors got money, like business loans, buying cars, billions, $22 billion. It'll make you sick.
Hi, Harris. Well, a new report today from a watchdog group shows that the Department of Health and Human Services has spent $22 billion on migrants over the last few years. We're talking things like cars, homes, even help with credit scores. And guess where this money's coming from? The taxpayers' pockets. Well, Open the Books is the name of this government watchdog group. They dug into this. Their investigation revealed the money was distributed through the Office of Refugee Resettlement, a division within HHS. The office has come under fire in the past. Last year, as everyone may remember, an Inspector General report revealed they could not track the exact whereabouts of 32,000 unaccompanied migrant children. And still, this latest report notes the most funding went to programs for unaccompanied migrant children. Other programs include matching savings for cars and homes, small business loans, and help with credit scores. In 2021, according to this watchdog report, they gave out more than $2 billion in grants. Check 2023 out. That soared to more than $10 billion. This was the same time we saw a record number of migrant encounters at the southern border.
Sick.
And in 2024, another $4 billion. Eligible groups for these migrants include from these grants, that is, include migrants from Cuba and Haiti, humanitarian parolees from Afghanistan and Ukraine, special immigrant visa holders from Afghanistan and Iraq, and unaccompanied minors.
It's a dollar that a family can't decide how they spend that money on their own. And that's what we've got to restore, is shift those dollars away from these wasteful programs and let families and individuals decide how they want to spend their own money.
According to the report from Open the Books, the two nonprofits awarded the most funds were the International Rescue Committee and also the Church World Services. We have reached out to HHS and the ORR to respond to this report and to ask them to justify these billions of dollars from taxpayer money. As of this afternoon, we have not heard back from them, Harris.
Well, we're going to see more on that when RFK Jr. comes in. And I think the little bit of fraud that we saw with USAID is just going to be the tip of the iceberg, and we cannot wait to see how far this one goes. But as it stands right now, the states of New Mexico, Arizona, Michigan, California, Connecticut, and the blue teams, including the one with the weird senators from Hawaii, all not looking like they're winning in Judge Chutkan's courtroom, and the Doge victory will continue ahead. All right, and now, my friends, we got one final segment on the day, and let's talk about you know who. Fani Willis, not going to be happy about this one. Supreme Court of Georgia now getting the brief from the defendants who are confirming that Fani should be disqualified, and she's fighting for survival on this one. Remember, she indicted a bunch of these folks, including President Trump, who's no longer on this list. since he has been victorious and beaten Big Fani and Nathan, but many others who were still being prosecuted by her: Michael Roman, Schaefer, Cheeley, Meadows, Kathy Latham, of course, Rudy Giuliani, Clark, and Harrison Floyd, many of whom we've covered here on this channel, all submitting now their petition to the Georgia Supreme Court, trying to disqualify Fani for good. Now, Fani was out over the weekend partying it up, and our friend Phil Holloway got this one clipped for us. Says, here are some pics from Fani Willis's inauguration. And we looked at the tickets on these things, man. They were pretty dang expensive, unless you wanted to sit at the magistrate judge's table, which is where the peasants sat. And it was like $2,500 for one of those tables, or like $500 a ticket or whatever. So I don't know how many people were there or not, but this woman was there, had one thing she wanted that night, which was a photo of Big Fani. They are there for the love of justice, having a party time for Madam DA. Okay, this was her inauguration party, and Jasmine Crockett was also there. So she was there, probably paying no mind to anything happening in the Georgia Supreme Court, because she had her attention on her lover, her ex-lover, maybe current and still lover, Nathan Wade, was also there in Fani land. And he looks good, man. $700,000 will buy a nice suit, nice pair of alligator shoes or whatever he's got on there, and a bow tie, celebrating his love and his nice payday with Fani. And shout out to Phil Holloway. Make sure you're giving Phil a nice follow over there for bringing us the juicy goodness. But here is what it looks like. You can see Ashley Merchant is the defense attorney who's taken the lead on this one, and she blew the lid off this whole thing some time ago, representing Michael Roman. And of course, there's going to be some legalese in here, but let's see what is happening, because they're now at the Supreme Court of Georgia, and they say, look, you know, this court only grants review in the most extraordinary of cases. Cases of great concern, gravity, and importance. And this case is not one of those. So just for context, Fani wants them to hear the Court of Appeals case and reverse it to put her back on the Trump prosecution. But the Court of Appeals said, no, you're gone. The sole issue before this court, Supreme Court of Georgia, is whether the Court of Appeals made a mistake when it said that what McAfee did, which is bifurcating the prosecutors, remember, he kind of split the baby. He said Nathan Wade could go, but Fani could stay. The Court of Appeals said that's ridiculous, obviously, that there was a significant appearance of impropriety, and Fani had to go too. So the question is, did the Court of Appeals screw up when they booted Fani along with Nathan? The answer is no, okay? Because the Court of Appeals and their opinion simply applied settled law to undisputed facts, Court of Appeals or Supreme Court of Georgia, you should reject Fani. The facts found by the trial court, Judge McAfee, are not even in dispute. Neither side even appealed them. The Court of Appeals adopted them. In particular, after receiving a briefing and conducting a multi-day evidentiary hearing, the defendants here say that Fani and the court determined that her conduct created a significant appearance of impropriety. She had a romantic relationship and a financial entanglement with Nathan Wade, whom she hand-selected to prosecute this case, and her Fani, and other course of conduct in the case. Now, importantly, the trial court expressly found that her participation in the case was encumbered by an appearance of impropriety, not by status, but because of conduct, like indicting each other at all hours of the night. Impacts more than a mere nebulous public interest. The trial court also struggled with, but ultimately denounced, Fani's conduct, noting that questions about whether she even testified truthfully came up. They lingered, remember? And it stunk the whole building. Indeed, the trial court described portions of her testimony as unusual, understandably concerning, and most damning, not so incredible as to be inherently unbelievable. Oh, Judge McAfee. Pathetic. The trial court and then was like, but we can let her be the prosecutor, but it's okay. It's because she's Big Fani and he was up for re-election. Pathetic. The trial court further criticized Willis and Wade's conduct, finding that she exhibited a tremendous lapse in judgment. She did so in an unprofessional manner, and that Wade's testimony was a patently unpersuasive explanation for how he lied on his divorce records, indicates a willingness on his part to wrongly conceal his relationship with Big Fani. And the judge just let him stay anyways, or let Fani stay. The trial court determined this significant appearance of impropriety so infected Fani and her team that the entire case was clouded by an odor of mendacity. Very stinky one too. And ordered one of them to go. Of course, Nathan Wade was like, perfect, man. I'll take my 700 G's, go on another cruise. The state didn't challenge any of that. Now, as the Court of Appeals recognized, allowing Fani to remain in the case when she actively participated in this scheme, participated and testified, unbelievable testimony, acted unprofessionally, and caused the entire prosecution to be under an odor of mendacity, was insufficient. Allowing her to stay on the case was insufficient to purge the problem. Now, after dealing with the deluge of improper actions by Fani and the significant appearance of impropriety, the appropriate remedy would be for her to recuse herself or to terminate Wade, said the judge. Like, what? After all of that, what? That's the remedy? Unsurprisingly, Wade resigned. Fani remained with her stinky odor. And hey, the Solomonic solution, right, splitting the baby, did not and could not remedy the significant appearance of impropriety. So the Court of Appeals found, obviously, she has to go too. Striving to shoehorn the Court of Appeals opinion into another category that the Supreme Court can hear, she's trying to say this is all new legal ground, but it's not at all. At most, what Fani is saying is it believes the Court of Appeals was in error. But the unique facts that justified their decision also advise this court against accepting Fani's case. There's little likelihood that these circumstances could or will repeat. The type of factual record that establishes Fani's misconduct is thankfully unprecedented in this state. We've never seen anything like this before. So we're probably not going to see anything like this again. With little likelihood to reoccur, the Court of Appeals holding is in essence already limited to its facts and is not an appropriate or viable vehicle for this court to make any changes. And so, they tell the Court of Appeals has the Supreme Court has limited jurisdiction. You should not accept petitions in this case, particularly this case. The Court of Appeals did not dismiss the indictment, didn't dismiss any defendants. It's not even a complicated case. All they did was disqualify her. The case has been tainted, and so she had to go in order for the public to have some faith in what's happening now. And so don't allow Fani to come in here. It's not a new type of legal argument. Georgia law allows you to get rid of Fani when there is an actual conflict, as there was here, and the appearance of impropriety, and when there's a fiduciary relationship. All of this is justification. Now, the state doesn't even disagree. They say she was elected to do her job. And in other cases, we've asked whether prosecutors were acting egregiously. They're citing a bunch of case law for us, so we're fast forwarding through that. But in some, the state's claim that the Court of Appeals erred is totally wrong. The doctrine is well established, as we just saw in those preceding paragraphs. Even if they did err, which it didn't, such an alleged error is insufficient for the Supreme Court to hear it. Now they say, Fani, that they misapplied the law. Well, that is also mistaken. We've done an extensive record on this. The Court of Appeals looked into all of those claims, and they looked at Blumenfield, and they found how that one favors them. And the state is interpreting Blumenfield wrong, but the Court of Appeals specifically rejected her arguments. And so, as you can see, a lot of legalese in here. The petition should be denied because it's about the remedy. The second argument is they're saying, well, the disqualification of Fani was an abuse of discretion. Okay, so maybe there was a conflict. Maybe she was improper and it had a stinky odor, but you shouldn't have disqualified her. There's another remedy. And they're asking about that. The Court of Appeals performed exactly the type of review that Fani's asking about, saying it's not a bad remedy. She says you can never disqualify us. We say you can. The dissent's underlying premise is wrong. We're fast forwarding through a lot of this. Let's see. And so you should deny Fani. It's fundamentally unwarranted here. Nothing conflicts with this court's precedents. Neither is this court being asked to reconsider any of its own existing law. The state has not shown anything, and they are dead wrong on the facts. This is a unique case. And there are also no underlying issues of great concern, like the court doesn't need to address something that's going to be catastrophic. So don't allow her to re-inject herself back into this prosecution. And media attention is not a basis for this either. The state, Fani, cites no case saying that well-known individuals have some sort of interest in front of the Supreme Court. And so you should not accept this. For the reasons set out above, this court should deny Fani's petition. Don't let her come in and try to get back on the case. Signed by Ashley Merchant, Christopher Anelwitz, and a bunch of other attorneys you see here representing all of these defendants. And so the idea is this is a pretty short attempt by Fani, right? Fani submitted her petition. The defendants responded, and Fani should not be allowed back on the case. And so if the Georgia Supreme Court rejects the petition and says, we're not going to hear this case, we're not going to schedule it for oral arguments, you're done, Fani's case is probably done because she'll have to get her entire office off, right? Fulton County's office is now gone. So she'll have to go to a different county, or some other county prosecutor is going to want to pick this up, or some other special person, and they're not going to want to take this case up. So a good conclusion and a good outcome here might ultimately be the inevitable dismissal of the case, because Fani can't handle it. No one else is going to want to handle it. And the weaponized, politicized prosecution of these co-defendants might finally be coming to an end. And then we can talk about repercussions for breaking the law with a malicious prosecution. But my friends, that is where we're going to leave it on the day. We covered some good filings and some serious briefings today. We had at the start the petition, or the application to vacate the lower order at the Supreme Court of the United States. So if you're just joining us and you missed that, hit the rewind button, because Trump is knocking on the door of SCOTUS. And it's a very nice filing that I think will just be the first marker in a long conversation about the federal executive, the executive power at the federal level. And it's going to be a lot of fun to discuss. Then we talked about the 14 blue states suing Elon and Doge for some reason. They don't even really know why. Judge Chutkan doesn't even really know why. They just want it to stop. Like the pain, they stop, it hurts, stop. But they don't even know what they're asking for. And it's not going to stop. Okay, things are only going to be picking up. Shout out to Margot Cleveland for giving us the inside take on what happened with Judge Chutkan on that one. Of course, we'll come back and we'll see what her final order is when that one drops. And then we just wrapped up the day talking about Faniland, Big Fani Willis in Georgia, Fulton County, and how she's not going to be happy to see the brief from the defendants hitting the Georgia Supreme Court, telling her that everything she alleged is already settled and she's not getting back on the prosecution ever. And so now, my friends, it's time to hear from you and to see what you have to say about all of this and more. It's a beautiful Monday. I hope your week is off to an incredible start. Even if you're just enjoying the President's Day and lounging and enjoying a bit. We had a lot of business to attend to today. We were looking at the updates on our morning stream from this morning, and it looked like it was going to be a light day, but it turned out we had a lot to get to, which I'm glad we did. What's up? New week ahead. Good to see you, Donut. Happy Monday, my friend. Snoopy with a little Snoopy off to make the week great. Thank you, Donut, for that one. Hey, Joe Dale. What's up, Joe Dale? Just became a new supporter over on the YouTubes. Grab the morning stream, and we'll see you tomorrow morning as well. I'd rather be skiing is bringing in 20 new membos. I'd rather be skiing. You're amazing. We're glad you're not skiing and gifting membos, and hopefully skiing afterwards. The D-Jantronic is here. We got Mike Matlock. What's up, JC Stick? We got Georgia Peaches, Susan Winchell, Winshittle in the house. We got Richard Parker. What's up, Riven Hex? AJ, my DJ here. We got Scott Hartman, B.I., Geloso, Michael Thompson, Kent Cook, Lord Reverend Pindragon, What's up to Schechter Dissector in the house? Not Gullible, Mr. Patrick, David de Rossier, Vicky Fox, Michael Stetson, and Bernie Smith. All gifted membos, courtesy of I'd Rather Be Skiing in the house. Great to see 20 new friends. We'll see you tomorrow on the members only stream. Hey, Ed. What's up? Ed 2276 says attorney Joe Neerman, good logic, of New York says Trump can beat the TROs by demanding plaintiffs post a bond of an amount equal to the courts, to funds the courts require Trump to release. Yeah, so that's an injunction bond. Civil Rules of Procedure 65C. Plaintiff won't post $1 million or $1 billion bonds, and so they'll drop the TROs. Exactly right. So that's what we saw in the filing today. Okay, so Trump's attorneys were asking for injunction bonds. That's what that is. And they won't be able to come up with that money, so they'll have to lose. Shout out to Joe. Check out Good Logic. He's right next door on the YouTubes, the Rumbles, and the Locals. Good dude. We love you, Joe. What's up, Joe? Hey, Glocky says, the people that wanted Trump out in prison, over 200,000 in an accounting ledger, sure fighting hard to protect the government accountants who lost trillions in tax dollars. Yeah, the level of panic that you're seeing out there right now is palpable. And the people who are freaked, they look as guilty as ever. Former says, is the government able to recover legal fees when the government prevails? No, I don't want my tax dollars thrown away defending against meritless and frivolous claims. Exactly, Former. And that's why the injunction bond is a good solution. Like, okay, if you're going to sue somebody and demand something happen, the way I've seen this come up most is in appeals. Like if you're going to challenge a traffic ticket is a very simple example of this. You lose your traffic ticket in court, you want to appeal it. Well, you have to post a bond. Like you don't just get to appeal it and continue to drive around. If you lost, your license gets suspended. You appeal it, you post a bond, so your license is unsuspended. And if you lose the claim on the appeal, you get the points assessed, you get the bond taken. You got to put some skin in the game. You don't just get to appeal on the government's dime and then you lose the appeal, then the government then has to suspend you and then has to go collect your money and like track you down for that. You got to post it in bond. You want to sue the government to injunction the enforcement of the executive branch, just like you'd want to stop the execution of the judgment against you in a civil ticket. You got to post something. It's pretty standard. So like do that. And hopefully the Supreme Court starts to clarify this for us. Glocky says, DNC is suing all Americans that voted for Trump, from Jake Tapper. Yeah. Good luck. Sheila Poo. These DC circuit judges need to be removed ASAP. Yeah, that's a tall order, Sheila Poo. Yeah, how are we going to impeach all of them? It's a tough one. But there does need to be some correction here. Ed 2276 says Judge McConnell is corrupt. Here's a Gateway Pundit report, and I saw a good report on him, I think from our friends at America First Legal. It says McConnell was on the board of NGO Crossroads, Rhode Island, even after he became a judge. The NGO got $128 million in government funding. His Trump ruling keeps the funds flowing to the Rhode Island NGOs. So this dude needs to be impeached. From Ed 2276. Yeah, and there's a lot of that. Like judges' wives or judges' kids or judges' family members are all on these NGOs. They're like, oh, crap. No, we're going to grant the TRO until her check clears on Friday. Then I'll cancel that. Thank you for that, Ed. Very nice donuts today. I appreciate you. Jeffrey Adams. I wonder if Justice Roberts ever regrets stating that there are no Obama or Trump judges, just judges. Truly one of the stupidest sayings ever spoken by a stupid, smart person. That's a Dan Bongino saying. A stupid, smart person. There's a lot of that. But I don't know that they're actually smart. They just think they're smart. Now, John Roberts is a smart dude. Like, no doubt about that. That dude's a sharp dude. Even though I disagree with a lot of what he says, I can recognize his intelligence from his writings and from other things. And yeah, anyways, but yeah, I mean, judges have political biases. Like it'd be nice fantasy land if we didn't have judges without biases, but I guess that's one spectrum. Obama judges, Trump judges. The other spectrum, which is kind of the same thing, would just be like living, breathing constitutional ideology type people or, textualist type of interpretation. It's kind of how judges interpret the law. And living, breathing Constitution people would be on Obama's side, and more textualist, just interpret the Constitution type judges would be on the Trump side. G-Men, what's up, G-Men? Says, so when does the Solicitor General go to SCOTUS with a simple question? Are nationwide injunctions by inferior courts constitutional? Clearly they are not. I believe Hamilton spoke about this in Federalist 78 question. Lincoln definitely spoke about it in his inaugural address even said Dred Scott was as applied and would only apply to Dred Scott, not a millimeter further. Isn't it time for the acting Solicitor General to do this? I know 4 justices will 100% take that up on cert. So, yeah, it's an interesting question, G-Men. I think, that's more of a TRO issue and not exactly what we're talking about right now. Like the TROs are the mechanism, but do we need constitutional law on TROs, or do we need to just articulate the bounds of the executive branch? So in other words, if a TRO can't go to something that the president is qualified to do. So the question is not necessarily about injunctions. It's about injunctions applied to the presidency. And if you define the outer bounds of the presidency such that injunctions don't reach them, then you don't need to have new case law on injunctions at all. You just have defined the outer bounds of the presidency, which is, I think, what Trump is trying to do right now with the Hampton-Dellinger petition to SCOTUS. It's a great question, G-Man. And I think it's a good question that should be addressed in general, but I don't think the courts really want to meddle with that, because then that creates a whole new kind of process and a procedural structure there. It's a great question. Maybe in this term we'll get to it. Hey, Jeff Pearson. What's up, Jeff? Thank you for becoming a member. We'll see you tomorrow on the members only stream, and grab the stream from this morning. G-Man says, if you look at the birthright citizenship stay from Washington, that should be as applied to the parties in the case only. Nobody not named in that case who is born here with illegal parents should be receiving Social Security numbers. There's no such thing as inferior courts putting a nationwide injunction on the executive. Okay, so see, that's a whole separate issue, yeah. And I see what you're saying there in the 14th Amendment. Yeah, I think you're right about that. I think you're right. Why should every other baby who's born to illegals now have citizenship automatically because some Washington state judge said that? You're right, G-Man. You're right about that. I stand corrected. Hey, we should have a decision on that so we can get that. Well, I guess on that issue, again, you could reach the merits by just having a correct interpretation of the 14th Amendment. Now, that being said, you still have that window, like all these babies being born right now to illegals who you couldn't. If the executive order is stayed right now, those people are having citizenship right now because of one single judge. It's a great point. Thank you, G-Man. Love it. Noble Spud is here. What's up, Spuds? Spuds, we hope you're having as best a day as you can, my man. It's really nice to see you. Spuds, Matt Smith is here, coming in as a membo. Richard Dean is here. David, what's up? Jacob Heidion joining us, and my name in the house, gifted membos, courtesy of the Noble Spud, who was here with us this morning. And we're happy to see Spuds back. We got this one from Sharpie Guy. Says, these activist judges are setting themselves up for an awful end of their career, right? I mean, I don't know. They got lifetime tenure, man. So please tell us how to help make that happen, Rob. I'm tired of this. Well, if there's corruption, I mean, if there are judges who have serious conflicts of interest, like that other judge and his wife getting rich or whatever from USAID, there might be some ethical avenues there. But if impeachment is the mechanism, forced, let's say, encouraged resignation due to political pressure, but impeachment, I don't think it's a very tall order. It's happened 10 times. Among Miller, what's up? Among Miller, good to see you. Thanks for becoming a membo and for joining us. We'll see you in the members only morning streams. Sheila Pooh, a million hugs to you. Thank you, Sheila, for bringing in 10 new membos. Check these membos out. Cheryl G's coming in. Beers and BS. We got Lawrence K. Edgett Jr. Welcome. Chris, Tricky Vicky's here. Amy Perkins, I believe, is here. Kimberly D. Clown World Observer. Lord Tatman's Comics in the house. And Sergeant Grinch, gifted membos, courtesy of Sheila Pooh. A million hugs to you. Samantha Richardson, did you get one? A membo? Hey, Tasadaka. What's up, Tasadaka? Says, I follow an SSDI lawyer. He was sharing that if someone were to pass away in another country, They might not have a death certificate. One example is a prisoner of war. They can't remove them from the book, so to speak. However, they are not receiving benefits. There needs to be proof of life. He wondered if those in his list was receiving benefits, or were they just listed because they lack a death certificate. Yeah, maybe commenting on Elon's list and trying to explain that list. Do we really have 15 million people over 110 or whatever the numbers are? Thank you to Sadaka. Hey, Benjamin Lewis says Elon and Mike Lee want in Fort Knox for a gold audit. Yeah, there's been weird stuff happening with gold. And I saw some other report that like tons of airplanes are flying back from Europe with gold. Like, are they bringing the gold back that they stole? Glocky, is Chutkan ruling most in favor of the government because the state AGs don't know what they're doing, or is she actually going by the law and the Constitution? It honestly sounds like the state AGs are just incompetent. Like, their complaint doesn't match their arguments, is what it sounded like we heard today. Like, you're saying all of these things, but you put in the complaint something else. So what is it? Where are you guys? Hey, what's up? Hi, Cy. Sev Russ is in the house. What's up, Sev Russ? Good to see you, Sev. Bringing in 5 new membos. Daniel Gygax. What's up, Daniel? Robert Velk and Anglo-Saxon is here. Steve Dubois. What's up, Steve? And Rage Star, gifted members, courtesy of Sev Russ in the house. Great to see you, Sev Russ. Silver Umbrella in the house. Look at these beautiful gifts, courtesy of Donut. Silver Umbrella, thank you for bringing in 10 membos. Look at this. James Johnson, Porsche is here. OG D-Dog, what's up? Seagull Gunner, Taylor Cook, Ogre, Catherine Malo, Kim Stone, Spectrum Wiz, and John Link. Gifted membos, courtesy of Silver Umbrella in the house. Thank you, Silver Umbrella, and welcome new membos. We got this one from Glocky. Says, this is about to get wild. Elon Musk and Doge have now gained access to IRS. That's tremendous. Time to audit the IRS. This one came in from Glocky. Here's one. We got some good memes here. So first frame, of course, is Republicans reaching a hand out to the 3-letter agencies. And the Republicans are saying, we can reform you. Hold on. We're coming for you. Glocky comes out with a 2x4 to the face. Says, oh, no, you don't. Get the hell out of here. Thank you, Glocky. 2x4 is a good option. Yeah, 2x4 is a good option. Here's one from another one from Glocky. IRS agents at your door. Says, hey, give me 30% of your income. Why? So I can save you. From what? From what I'm going to do to you if you don't give me 30% of your income. Yeah, and 30% is like a cute number. Okay, it's like not even real. Like, you add it up. Okay, add all your fees and your taxes for your water and your gas, like 50 cents a gallon, some places. Add that every time you travel, add your sales tax to it. Every time you spend, we're taxed into oblivion. It's disgusting. Glocky, they really don't want their illegals deported. They would rather overthrow a duly elected American instead of working with Trump to deport illegals. It's unbelievable. Says, New York comptroller is demanding that Eric Adams submit a contingency plan or he's going to be removed from power. Wow. New York. Glocky says, the media is such a clown show. Here's a fact check. The Clinton initiative cut 377,000 jobs, but it's not comparable to Trump. All right. Glocky says, they are fake employees, Rob. 60 Minutes pulled in 2 comms consultants who were never even actual USAID employees. Wow. Those 2 that we just played that clip from are just consultants. Like, I don't know where my money's going to come from. My kids are going to die. Okay. Another one from Glocky. 60 Minutes aired an interview, but the same woman confessed to taking incriminating books with her after Doge entered the building and she deleted her X account. Wow. What a terrible situation person. Hey, James Anderson says John Fetterman is the embodiment of a human Shrek. He does look like Shrek. Yeah, he does. Not as intelligent, though. Member for 1 month. Great to see you, James. Hey, what's up? GTKA Steve. Good to see you, Steve. Says, awesome stream. Your info quality is unparalleled. Thank you, GTKA. We try to have a high density of information in this stream. Like, I try to cram as much info as we can in the time. I want more information per minute than other shows. I think is a good metric. Not all other shows, because it can be too fast, and we go in deep, but we want maximum info. Voice of the People says, finishing the foreign affairs hearing tonight on Off Label in 1 hour. Go check it out, Off Label podcast. The screaming is about to begin because they caught them laundering your money, and it's priceless. So head over to Off Label podcast 1 hour after the show and check it out. Have a great stream, Voice. Jerome Lambert, what's up? 11 months as a member, almost 1 full year. Thank you, Jerome. See you on the Membo stream tomorrow. James Anderson says, here's small and simple things make great things come to pass. A 1 millimeter miss has brought us the most government reform in political history, and it vindicates America. Man, you're so true, James. So true, James. G-Man says, so not even considering the Washington case, do you think an inferior court can stay an executive EO with a nationwide injunction? Well, I mean, they're doing it right now. I think it is certainly a precarious position to be in because it's being abused. And I think if you go down to it, it's like there is one Supreme Court. So an inferior court is not the same thing as the executive branch, just structurally speaking. So if the Supreme Court were to come in and then say Trump can't do a thing, then that I would say is binding, right? But you also want to respect the courts because there's a political consequence to not respecting the court. So if Trump right now violates some order from some hack judge, even if it is a hack judge, his remedy, right, is to take it up to the Court of Appeals. Would be the response to that. Take it up to the Supreme Court, wait for them. And that would also be, right, that's the remedy. Like that they balance these things out, the Supreme Court. So can Trump violate them until it it basically disregard an injunction until it reaches the Supreme Court? And is that, I think probably, yeah, he can, because what's going to happen to him? The judges and the judiciary can't enforce anything. So the only real consequence there is political. And then what does that do is it creates a new political attack vector for the Democrats to then say he is openly flouting the courts. And then they would try to impeach him for that. Now, the argument would be, well, the Supreme Court hasn't said that these things, and these are hack judges who are abusing this lower level process. But I still think that his best political attack or his best political mechanism is to take it up to the Court of Appeals through to the Supreme Court, where I think he'll win, and then settle that issue. But legally, I think that if Trump wanted to ignore a district court ruling, he could. There would be political consequences for that, and he would only be in real violation of the constitutional structure if the Supreme Court told him he can't do that thing, and then he did that thing anyways. Because the Supreme Court is the co-equal branch, not the district courts. So it's a complicated issue. Spitfire, what's up? Thank you for the questions, G-Man. Don't know if I answered anything or made it more murky, but thank you for the great questions. Spitfire, what's up? Will Crump says impeachment proceedings against one judge might scare the others back into line because they don't think it will happen. Yeah, I think that's right. You got to impeach one judge or indict one judge or investigate one judge. And I do think the rest of them realize that there's a new sheriff in town. So, my friends, thank you so much for sending in those great comments and those donations. Let's say hello to our friends on X before we wrap it up for the day. Let's see who's joining us over here. Hey, B Torn. Yeah, B Torn, talking about good logic and bringing up the injunction bond. I think that's right. I think it's a good take. James Pepper says, send him to the Bering Sea with his office and he can do work there. Fred says, Rob, I've been screaming about these judges for years. Biden's Democrats approved 200 activist judges in the last 4 years. Not one no vote by the Democrats. Thank you, Mini Tika, for plugging Rumble. Jody, thank you, Jody. We will keep up everything here. Tanzer, great to see you. And TJ King, great to see you. Telling us more about Amy Berman Jackson. Yeah, the DC judge. And great to see our friends on X over there. Of course, you can follow us over there on X and follow other watchers in the wild over there. We have Away the Stone on YouTube says, executive is the pilot and take care clause is the checklist he does before every takeoff. If it's failing now, mechanics, the Supreme Court, are here to verify his concern. From Away the Stone. Yeah, I don't think that any independent agencies really exist under the Constitution. They fall under the executive or some other branch, but they're not independent. And Away the Stone, thank you for sending that one in too. Yeah, hopefully the Supreme Court comes out, clarifies this for us, and we can proceed accordingly. All right, and so my beautiful friends, thank you so much for sending those amazing donos in. Very much appreciative of those. We are now going to thank our incredible mods and meme smiths. You know who they are. The always amazing K-Bean, Donut Mind Me, Carrie B, Playin' Hooky, Dog Digger, and Janik, modding the fort down for us, keeping things oh so nice and beautiful. We are going to wrap it up right there. We're heading over to locals. We're going to debrief for a little bit. And then, of course, we are coming back here tomorrow. And we're going to get into it again. And in order to do that appropriately, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.